But it hasn't been see that since the last 13 years, with respect to paying the auction money, we haven't received the compensation from home.
Yeah. You have filed the bail application. All item. Yes. Yes. Yes.
Since directing the present petitions to grant analysis of petitions, are part of the unit those who have reviewed, those who have referred to the other.
10%?
Content proceedings are already innocent.
Why do you not comply with the order? Have we challenged the order before?
Mistaken information instruction on our part, the date has been disposed of as infectious.
Can I make a mention?
Yes, Mr. Pujari. Huh? Yes.
Can I make a mention out of list? Lord, can I make a mention out of list?
No, we are there. You have to take up serially, Mr. Pujari. Why are you mentioning? I thought that you are mentioning for adjournment. So please wait.
Lord, can I make a mention out of list, my lord?
Yes, Mr. Mishra.
Lord, there are two writ petitions by 3 foresters. Those who are selected, appointed, and joined the service, and from 10 years back, 2015, they have been suspended. They approached the tribunal, rejected, and it has come to this honorable court, and it was about to be heard on merit before another bench of this honorable court. And they are out of service, no suspension allowed, and without show cause, they were suspended. And during pendency of the case, it was intimated that they have been terminated also. So both the petitions that it may be disposed of because they are for 10 years out of service, no suspension allowance also received.
Please give the numbers, Mr. Mishra.
Lord, WPC 20341.
Yes.
And
give a memo also.
Please give a memo, Mr. Mishra. Please
I am giving memo 2034123 and 1638023. I am giving memo.
Please send a memo so that it can be taken care of. Okay.
Maybe sometime listed next week if possible,
Okay, we'll do that.
I beg your pardon, my lord. I pray, my lord, to withdraw item number 19, my lord. To withdraw item number 19. I've also filed a memo for withdrawal of this matter, my lord.
All right, Mr. Ashish Kumar Mishra, Land Council, appearing through virtual mode, seeks permission to withdraw the writ petition. And to that effect, he has also filed a withdrawal memo, which is at flag A. In view of such memo and submission made by Mr. Mishra, the writ petition is disposed of as withdrawn. Yes.
Highly obliged, my lord.
Supplemental list, item number 1.
Item 2 will be passed over one item. One may be passed over.
Who is asking for passover?
Item 2 may be passed over.
No, we are in item 1.
Pass over.
We are in item number 1. Yes. Why have you filed this memo so that the matter has come for to be mentioned? Four 9. Yes. Okay. Yeah.
Following demands as raised by the appellants are required to be brought to the knowledge of this board. One, this is actually one. Expedition and timely completion of the work at the resettlement site as per the approved plan, preferably within a period of 6 months. Two, to provide company quarter at the transit accommodation for 25 number of applicants within a period of 1 month, and the subsequent to which said applicants shall vacate their lands in the acquired area within a period of 1 month. 3, 4 we are not concerned. If you looks at operative portion, Mr. Natraj, noted ASTI, and Mr. Acharya, instruction of fairly submitted that.
Just a minute, Mr.
It's all
Mishra.
right.
Yes,
Proceed.
yes. Please, Mr. Mishra.
Advocate General, instruction of fairly submitted that. In so far as demand 1 and 2 that I read just now.
Yeah.
Are concerned, the same should be accepted as it is. In this regard, in regard to the other demands, the same would be given as to the entitlement in accordance with RNR rules 2006 on the basis of the individual entitlement eligibility.
You are concerned about 1 and 2.
Yes.
So what happened?
Affidavit, let's look kindly.
Affidavit.
They because you are directed them to file the affidavit.
They have filed the affidavit. Yes. Yes.
To that effect, the detailed affidavit has been filed, which is taken on record.
Yes.
Same day it was filed, in fact, copy served in the late hours.
Yes.
That affidavit, if you looks at para 4,
Yeah.
that I say that the resettlement site work is in advanced stage. In response to the affidavit filed with the petitioner in this case, MCL company would acknowledge they have accepted these 2 terms, as your lordship indicated, acknowledge the demand of mentioned para 10A1 and 2. That is quoted, submitted as an earnest attempt would be made to meet the demand of the land users. That so far as para 10A2 is concerned, it is submitted that out of all the persons in terms of list enclosed in the affidavit, so we are not concerned. But so far as if your lordship looks at 1 is concerned, they have not indicated in the affidavit.
That has been indicated in paragraph 4.
No, it is, yes,
Paragraph 4
The company would acknowledge the demand as mentioned.
Acknowledge means these are the 2 demands we accept. In that
it is not, may not be happily worded as per your this thing, but
no,
it
not
is,
happily worded. In fact, acknowledgement is something else. That means yes, your demand we see. We understand your demand.
but in the end it is written, it is submitted that the earnest attempt would be made to meet the demand of the land.
Say here, neither here nor
No, it refers to obviously Roman 1 and 2, and it is mentioned that an earnest attempt to what further you say.
Yes.
No, we have to comply within that period. That was the demand.
No, that's correct.
That is.
I don't think there is any quarrel. It may be not happily worded, but there is no. Insofar as 1 and 2 is concerned, you have agreed to that, isn't it?
Both Mr. Advocate General, Mr. Natraj was there.
Yes, I am here. Kindly see their proposal itself speaks about it. Kindly see para 4.1, which is extracted.
Yes.
Expeditious and timely completion of work at the resettlement site as per the approved plan, preferably within a period of 6 months. That is their own affidavit.
Yes, they are their own affidavit.
What else is?
No. What they say is, as far as these 2 conditions are concerned,
correct.
It is the affidavit is not coming forth whether you are complying those 2 conditions or not.
No, when they say that, when they say that it is preferably within 6 months, their own affidavit, can we say something beyond that? Saying that
I don't think he's saying anything beyond. Only see within 6 months it will done, then he's happy.
Preferably, he himself said it preferably. That's all.
Outer limit is 6 months.
Outer limit is 6 months.
Preferably means not outer limit.
Maybe prior to that.
Preferably has something with a different connotation.
No, we are not in a. We said that why this matter was mentioned actually.
They want to drag on the matter. That's all.
So please, I don't think that comment is not acceptable. In fact, it's a confusion. That
No, there is confusion. We will clarify.
That's right.
We'll clarify this.
Clarify that. You should clarify in the order. Because I know Sir,
No, there is no
option of
nothing, sir.
making a comment
If
that
they would
you
not
want
have
to write.
quoted, Mr. Mishra, they have quoted 1 and 2 and exact language which you have quoted.
Sir,
They have stated.
acknowledge.
That acknowledge all
The
it.
persons to the order dated 4/9/2025, the respondent filed an affidavit dated the affidavit of the same day, inter alia, contending as under para 4 and 5. The matter was subsequently mentioned by the learned senior counsel appearing for the petitioner, expressing apprehension that insofar as the condition number 1 and 2 is concerned, the affidavit is not expressly, affidavit doesn't expressly mentions as to whether these two conditions will be scrupulously complied or not. The matter was again listed today for hearing. The learned counsel for the learned senior counsel, Mr. Nataraj, learned AC, and Mr. Vitamarachaja, learned Advocate General, APS for the respondent, and submits that there is no quarrel insofar as condition number 1 and 2 is concerned. The affidavit may not be happily worded, but the respondent stick to the undertaking given before this court that insofar as the condition number 1 and 2 are concerned, they will be complied in the letter and spirit. With this clarification, the
Matter is
matter
reserved.
matter is resolved.
Judgment is reserved.
Deeply obliged.
Deeply obliged.
Item 2.
May I please? In this case, against the inaction of the opposite parties by not giving a service connection to my premises, my lord, I approached the GRF, and against the order passed by GRF, I again, since my grievance was not redressed by the grievance redressal forum, my lord, I approached the ombudsman. And the ombudsman, my lord, what he did do, my lord, without analyzing the provision of law also, he has said that I am liable to pay the arrears of a tower, telecom tower, which was installed in my land. And on the allegation that there is arrear against the tower, so I am to pay that.
Yeah.
He has relied the provision of regulation 17, my lord, which is not at all applicable. So this regulation 17 came into effect with effect from 2019. My lord, the dispute which they says that the tower was there, that was defunct since 2013, my lord. And the tower was removed from my land.
2013.
13, my
Or
lord.
of 2017.
My lord. My lord, no, 2013, my lord, have a glance to the, that page, my lord, page 43, my lord, have a glance. I have,
Come to page number 2 of the order.
my lord.
Page number 2 of the order, impugned order. Running page is 40, and it is right, it is written that from May 2017, there was no power supply to so and so.
My lord, that
So
is,
the Disnet Wireless Limited
my lord.
had constructed a tower on your land.
Yes, my lord.
Power was supplied.
Power was given by the department. I have never given any undertaking that in case he will leave in
No.
area, I will pay. That is first thing, my lord. Even if, my lord, he has no area. Lord, may have a glance to page 45, my lord. That he has, it is a wrong observation he has made. The licensee did not produce the record of disconnection, though as per regulation.
Then according to you, who will pay then?
My lord,
Arrears who will pay?
no, if area is there, the whatever conditions are there, agreement was executed by the supplier with the consumer, my lord. As per the agreement, my lord, as per regulation 16, my lord, if the power supply
No,
is
he has
disconnected,
gone. He has gone.
my lord, he has gone.
So
My lord, so far, my lord, so far the
it was
existing-
taken. It is
Suppose, my
between
lord,
you and
I am speaking in general, my lord. Suppose I am a consumer, I have taken power supply, my lord.
yeah.
Suppose I will leave the
Without your
place
landed
within area, my lord.
without your landed documents
Yes, my
being filed with the authority,
My lord.
can they give any electric connection?
Yes, my lord, they have
Your
given
price-
without my landed document, my lord, they have given and they did not produce the power supply agreement. What agreement I have made with the destinate wireless Miller, basing on that document, Miller, they said that you are liable to pay the area of this. Lordship, have a glance to the.
Just a minute.
You pay and recover.
How without your consent, the power supply can be given to a tenant who is staying in your.
They can give also, Miller. They can give. Miller, suppose I have constructed a number of shop rooms.
For that,
The owner is not liable, Miller, because they are, by virtue of the rent agreement, they are showing their occupation on the premises. They are to take.
What is the amount? What is the amount, by the way?
Miller, amount ସେମାନେ ସାର୍ କହୁଛନ୍ତି disconnect ହେଲା ପରେ ଯୋଉ ବିଲଟା
How much? How much?
ଯୋଉ ଫେକ୍ ବିଲ୍ ଗଡେଇଛନ୍ତି ସାର୍
How much you tell us?
ସାର୍ ସେମାନେ କହୁଛନ୍ତି ସେମାନେ ସେଇଟାକୁ କ୍ୱାଣ୍ଟିଫାଏ କରିନାହାନ୍ତି.
Wait, you tell us.
97,300.
For that, you pay.
Miller,
It's not
That is
usual.
mentioned there in that order.
Yes.
The second sub.
Yes,
paragraph.
97,300.
That was one of
How-
April
how the
2018.
power supply is disconnected on a particular date, how the fake bills will be accumulated, why they will accumulate fake bills in the same of the consumer. The Lords may see the billing statement I have filed. Lords may see the billing statement. 45 page 45, Milord. Milord, actual billing was done in the left hand side. There is actually a CT. Page 45, Lords, you have a glance. Milord, there is actual consumption till 9/2016. ତାପରେ ସାର୍ ଆଉ କନଜମ୍ପସନ୍ ନାହିଁ 43,957 ହେଉଛି ତାଙ୍କର ଲାଷ୍ଟ କନଜମ୍ପସନ୍ ୱାଜ୍ ମିଟର ରିଡିଂ ଦେୟାର ଆଫ୍ଟର ଆଉ ନୋ କନଜମ୍ପସନ୍ 0,0,0,0 ମିଲର୍ଡ ଆଜ୍ ପର୍ ରେଗୁଲେସନ୍ 16 ମିଲର୍ଡ ଇଫ୍ ଦି କନଜ୍ୟୁମର ସପୋଜ ଦେର୍ ଇଜ୍ ଏରିୟର ଲାଇସେନ୍ସ ଇଜ୍ ଅଣ୍ଡର ଓବ୍ଲିଗେସନ୍ ଟୁ ଡିସକନେକ୍ଟ ଦି ପାୱାର ସପ୍ଲାଇ ଡ୍ୟୁ ଟୁ ନନ୍ ପେମେଣ୍ଟ ଅଫ୍ ଏରିୟର ଇଫ୍ ୱିଦିନ୍ 2 months ଦି କନଜ୍ୟୁମର will not take any step to get the supply restored ମିଲର୍ଡ then the agreement with the supplier will be deemed termination. There will be deemed termination by agreement. And what is the Lordship may see the regulation I am placing before you, Lordship. Lordship have a glance. I am placing, Lord. The Lordship may see 49 regulation. My Lord, it is as per regulation 16 of the 2004 code, and that is the same is perimeter similar to regulation 49.
Which provision, just tell us.
OERC distribution conditions of supply code.
Are you holding this book?
ସେଥିରେ ଅଛି ସାର୍ ଏଇଟା ମୁଁ ଦଉଛି ଲର୍ଡସିପ୍ ହାଭ୍ ଏ ଗ୍ଲାନ୍ସ ଟୁ ଦିସ୍ ସେଥିରେ ଅଛି OERC distribution conditions of supply code 2004
କହିଦିଅ
Condition of supply rule. Also, regulation number
regulation
49.
49.
Mobilize and entity.
I have got my lord.
OERC condition of supply code 2019.
OERC distribution condition of supply code 2019 my lord. Lordship may glance to
49.
49. The same is also.
Read it now.
My lord. I am reading. 49. If power supply to any consumer remains disconnected for a period of 2 months or above for non-payment of charges or dues or non-compliance of any direction under this code, and no effective steps are taken by the consumer for removing the cause of disconnection and for restoration of power supply, the agreement of the licensee supplier with the consumer for power supply shall be deemed to have been terminated on expiry of the said period of 2 months without notice provided the initial period of agreement is over. Milord, here
no from what about the liability of the payment? Their meter remains there.
Milord, meter nahi kichi nahi tower ta 2003 ରୁ ଗଲାଣି ଆମେ ତାକୁ ଚିଠି ଲେଖିକି ସେ ଆସୁଥି ଆମର
meter nahi meter ଖୋଲିକି ନେଇ ଗଲେ ନା କଣ
ডিপার্টমেন্ট নেইଥିବ নହେଲେ ସେ ନେଇଥିବ ସାର୍ ଆମେ
ଆପଣ ମାନେ it is on your land you have
ସାର୍ ମୁଁ ଗୋଟେ ଲ୍ୟାଣ୍ଡ ରେ ତାକୁ ଦେଇଛି ସେ ଟାୱାର କରିଛି ତାଙ୍କ ଭିତରେ କଣ ଆଗ୍ରିମେଣ୍ଟ ହେଇଛି ମୁଁ ତାଙ୍କର କେବେ ପାୱାର ସପ୍ଲାଇ
You have given no objection for the purpose of installation?
I have not given.
How will you know?
କରୁନାହାନ୍ତି ତାଙ୍କର ଆଗ୍ରିମେଣ୍ଟ ତାଙ୍କର ପାୱାର ସପ୍ଲାଇ ବିଲିଂ ଇଏ ସବୁ ସେମାନେ ପ୍ରଡ୍ୟୁସ କରିବା
have you seen that
then lordship another clause I am also referring lordship may have 51 regulation.
Have you seen that decision case in Inan case? K.C. Ninan, which the court has, the ombudsman has referred to. Have you gone through that case?
That is owner's liability.
Yes.
Owner's
Have you
liability.
gone through that decision?
I have not gone. Other decisions are there.
That is your first duty should go. When the
What is your liability?
the ombudsman has referred to a particular case and said that you are liable.
That
How
ratio
you are
is the same, Milord. Ratio
No,
that whenever
question of no. You should have placed this decision that decision is not applicable.
purchase alienation transfer ସେଗୁଡାକ ହବ ଗୋଟେ plot ଯଦି
How you are
transfer
not
ହେଇଛି
prepared with this case?
sir ସେଗୁଡାକ
Where is in which
Sir,
decision it is reported? Case
Sir,
in Ninan case, have you gone through it?
sir ସେଟା ମୁଁ sir ଦେଖି ଜାଣିଛି
No, ଜାଣିଲେ କିଛି ହବନି.
ସେଇଟାରେ ହେଇଛି ଯଦି
ମାନେ present କରିବେ.
land is subdivided ହେଇଥିବ କି transfer ହେଇଥିବ
Why are you not
sir
facing that
question of
case?
transfer does not arise.
Come with that decision. Case in Ninan case. Are you aware in which year it has been reported? In which journal?
ନାଇଁ sir ମୁଁ ସେଟା
Then
I have not verified that.
Yeah,
କିନ୍ତୁ
on
when
the-
The entire
billing
case,
statement let's see the tower has paid
on
maximum
fact,
amount.
we will not get into.
Milord,
On the law,
this
law,
provision says and Milord the
and you answer who will pay
Milord
to the discount.
Milord if there is arrear outstanding the person who has executed the agreement he is paid. If I have
he
indemnified
has
my
gone
liability,
somewhere. He has gone. He has gone now.
Milord, he has gone.
Yes.
Then what prevented the licensee not to tell the exact date of disconnection, Milord? Why you will say that?
You come with that decision. This writ petition has been filed.
Lord may say also regulation 51 for the moment.
No, you come.
The license is to maintain the record of a disconnection.
Okay, come with that judgment.
And ombudsman said to କହିଛନ୍ତି GRF kale the record of a disconnection is not available with the
Stop
license.
or not? This petition has been filed by the petitioner Dhirendranath Sahu, challenging the order dated 22/2/2024 passed in case number 6 of 2024 by GRF Cutter, and the order dated 13/1/2025 passed by the Ombudsman -1 in CR case number 21 of 2024. On perusal of the order of the Ombudsman, it appears that the decision of the Honorable Supreme Court in the case of K.C. Ninan versus Kerala State Electricity Board and others has been relied upon, and it was held that the owner of the land, that is the petitioner, is legally enjoined with the bounden duty to clear arrear electricity dues, and the owner of the land may recover the amount of the arrear electricity dues from his licensee, Messrs. Disnet Wireless Limited, under recourse to law, if so advised. But the owner of the land is legally duty bound to clear the dues in respect of the unpaid arrear electrical dues as raised by the discom Hobanito, as raised
Sir ସେଟା ଯୋଉ
unless and until
ସେ ସେଥିରେ
the
ଲାଇସେନ୍ସ
claimant
ଦେଖିଛି
public petitioner
ये
clears
सब
the
court कर
electricity dues, a legally sustainable direction cannot be issued to the respondent to provide power supply connection to the claimant oblique petitioner. Stop. When we ask the land council for the petitioner regarding the ratio decided in the case of K.C. Ninan, he seeks some time to go through the same and place the matter, put up this matter on
Next week.
15th of September 2020.
Lord, may I pray, Lord, your Lordship, may
Yes,
pass
yes,
an
yes.
interim order subject to
Just a
outcome of
minute.
this case, Lord.
Case in the report AG 2023 SCC, report AG. Yes,
Lord, Lordship, may pass interim order
no
to
question.
take power supply. Lord, I will
No,
abide by
sorry.
the result of this case, Lord. If I will be held liable, Lord, then I will.
We have not entertained the writ test.
We are likely, we may dismiss the writ petition. Yes.
2019 code applicable no.
That
So,
we'll see that.
17 अनुसार ମୁଁ ଦେବି ସେତେବେଳେ
15
if will go see Lordship see the
You just
2004 code which is
First of
applicable.
all, you satisfied us for purpose of admission.
Yes, next.
Your
Then
Lordship,
interim order.
Lordship call it, Lord.
15.
15, yes. Item number 3.
Item 3.
In this case, I am sure opposite party. I got in first occasion, my lord said,
No, last time it was said that he said that covered by judgment of this court in writ petition number 43110 of 2023. You are supposed to check it. You covered or not?
Well, this is also covered, this matter is disposed of by the honorable court in light of the upping mercy.
It's covered or not?
This is covered.
Covered thala au tako. If what kind?
As, I mean,
audit.
in the Jagdish Singh Keller,
Have you challenged that order in writ petition number 43110 of 2023? Have you challenged any?
that matter was challenged before the appellate court.
Which one? This order dated 10/1/2024. You have challenged?
That was pending.
So was
Sorry,
I have taken instruction today morning.
We are writing it and let me.
So are you-
The General Counsel for the Union of India submits on instruction that the order dated 10/1/2024 passed by the division bench of this court in WPC number 43110 of 2023 has been challenged before the Honorable Supreme Court. Let the Land Counsel for the petitioners produce the case number and the status of the case on the next date, put up this matter on 15th of September 2020.
Item 4. Item 4, Your Lordship, is listed day before yesterday. Your Lordship added to take instruction regarding the implementation, the status regarding the implementation of the order. I request some more time. Kindly refer to the order number next week.
କେବେ କହିବା ଆପଣ କୁହନ୍ତୁ ଆପଣ ହିଁ କହିଲେ ଯେ ପହରଦିନ ରଖନ୍ତୁ ନେଇ ଆସନ୍ତୁ
I requested
all
for
right.
10 days of
we
time.
are actually keeping to next week. You said that
Mr.
let
I
it be on-
requested for 10 days of time. This is somewhat like.
You tell us a date.
there is an order already, you have to comply, that's all.
Yes, sir.
And this honorable court will already, the coordinate bench.
It's already-
did earlier.
19th or 22nd.
90.
The Land Council for the state submitted that she is yet to receive the instruction as per the order dated 8/9/2025 and the matter may be taken up next week. Put up this matter on 19th of September 2025. Yes.
Item 5.
And I'm waiting for opposite party number 224. The file wakalat number. So not copy. So not.
For ଆପଣଙ୍କ ନାଁ ରିଫ୍ଲେକ୍ଟ ହେଇନି କହୁଛନ୍ତି ନା କଣ?
Replacement.
ଓ ରିଟ୍ ପିଟିସନ କପି ଦେଇନାହାନ୍ତି ଆଚ୍ଛା।
Reflecting. Not reflecting.
Yeah, who is appearing for petitioner? Please give a copy of the writ petition. Please give a copy of the writ petition. Let me go. What is your good name, Land Council? Acha, SP Jena.
Yes.
Mr. SP Jena, Land Council, appearing for respondents number, sorry, opposite parties number 2.
BSNL man, opposite party number 224.
Just a minute. BSNL also. Just a minute. Let us see. Opposite party number BSNL, 2, also BSNL. Eastern Telecom Region.
Opposite part number 4, madam.
4.
Yes,
You are appearing only for opposite party number 4.
4.
The contesting party or what? Is the respondent number 4 is a contesting?
Yes, we got from respondent.
Have you seen the opposite parties list? देखी भलो ही कौन तो कहाँ पाई वकालत ना वो फाइल कर दें 4 ना 3
4, madam.
3 भी अच्छी चीफ मैनेजर मैनेजिंग डायरेक्टर भारत संचार निगम कॉर्पोरेट गुड़ा को अच्छी है
Actually, they should
ठीक है
appear
रोहन
from
तो जे कहाँ पाई आगे सुनी चलो हमें आप पीछे अपीयर कोर्चन हमें जानी चलो
ETR पे है.
ETR.
Yes, madam.
Okay,
Alright.
4.
SP Jena Land Council appearing for opposite party number 4 submits that the Land and Council for the petitioners may be asked to supply a copy of the writ petition stock. Let the Land Council for the petitioner supply a copy of the writ petition to the Land Council for the opposite party number 4. Put of this matter on 15th of September.
We are for the 1 to 3 then. This 4 is land pen is appearing. We are
Mr.
number 1 to 3.
Deputy Solicitor General Fari is present, who is for the opposite party number 1, 2,
2 and 3.
3. 1, 2, and 3. What about this divisional manager telecom by number 5?
That divisional engineer we also we are appearing. Yes.
अच्छा, तारे 1, 2, 3 and 5 कर दो. You have, Mr. Pari, you have received the copy of the writ petition.
1 copy of receipt.
Okay, that's all right. Yeah. It will come on 15th. Yes.
Let me make a submission. Your lordship will permit me.
Yeah.
Whether in identical matters, some of them came before the Supreme Court filing a contempt. The Supreme Court granted them liberty. We filed that order to file a writ petition.
Please give him a copy. He is not having a copy. He is entitled to
just
get a
saying that
copy
this is
so
my
that he will go through it and we are.
Virtually notice, they are accepting notice.
Now there is no question of issuance of notice.
will
Everybody
hear
has
it in
appeared. Give him a copy. He is entitled to, and we are taking up this matter on Monday. What is there? Yes.
We hear it and finish it up.
Yes.
And they might have to file a response to this.
Please give it copy.
And one more thing, Mr. Mishra, you have to place on record the copy of OA and the pleadings also.
I'll do that.
Please do that.
Would your lordship give me some more time?
The
can
writ
take it up
petition
on-
has been, let it go. The writ petition has been filed challenging the order passed in under Annexure 1 series. However, we find that the pleadings are not available on record. Let the Land and Council pleadings which were made before the Central Administrative Tribunal have not been annexed to the SWAN. So let the Land and Council for the petitioner file the original applications, copy of the counter affidavit and other regender file itla. Yes.
If regender was filed, that also you file. All pleadings. All pleadings.
Your lordship may need it all.
Yes. Next.
Your lordship may also permit me to file additional documents. There are certain additional documents which I.
File whatever you want, but we want this.
Very well. Could
Yes.
your lordship list this not on the 23rd or 24th of October?
You don't want it on 15th.
Let,
All right. Put up this matter on
23rd October.
23rd October. It cannot be
24th of
listed,
October.
but can be listed on 24th.
24th October.
Very great.
24th October 2025. Yes, next.
I beg to pardon, my lord.
Pardon?
Item number 3.
Wrong space, wrong something.
This matter was on to challenge before the appeal court, that was not. So I am sorry, my lord.
Wrong
Not
something.
challenge.
No, not challenge, madam. That's the same.
Made a confident statement.
No, see, just suppose.
Order passing.
I'm gonna go to the next room. Can you?
That was your order tile. Paper लिखी जेतिक order paper लिखी later on the Land and Council for the petitioner submitted that he has just received the instruction that the order has not been, the aforesaid order has not been challenged. Jethin agent paper लिखी. However, the matter be placed on 15/9/2025 Sirlekha is already put up this matter on 15. The correct state of affairs regarding challenge of the order dated so and so shall be apprised by both the parties. Yes, next.
Item 6.
You have challenged the e-auction notice. Alternate remedy is there. Still you are 1, 2, 3, 4 adjournments you have taken.
All right, affidavit you filed. What is there now?
Reaction could not be taken up if you have an absence of bidder.
Though you approach the bank. All right, we are just disposing of this. Writ petition has been filed by the petitioners challenging the e-auction cell notice dated 37/2025 under Annexure 3, which was issued under the Surface Act 2002. An additional affidavit has been filed by the petitioners, wherein in paragraph number 2, it is stated as follows. Quote the entire paragraph number 2 of the additional affidavit dated 8th of September 2025. The Land Council for the petitioner, Mr. Maharana, submits that since the e-auction has failed, the petitioners wants to withdraw this writ petition to approach the bank for amicable settlement. Accordingly, the writ petition is disposed of as withdrawn. Yes. For one-time settlement, disposed of as withdrawn. Yes, next. Both matter same. Both matter same. তাদের মধ্যে affidavit file করছেন।
Not explicitly.
It is made clear that we have not expressed any opinion on the merits of the case. Yes.
Otherwise, you will go and say that I couldn't say.
All right, all right.
Item 8.
I filed a caveat petition and request him to serve it. Not taken up some other way so that you can go through this.
Mr. Sasibhushan Jena, Land Counsel for the Caveator is present. Land Counsel for the petitioner served the copy of the writ petition on the Land Counsel for the Caveator in court today. Mr. Jena submits that he may be given some time to go through the writ petition and the matter will be taken up next week. Put up this matter on 15 ରଖିବ ନା 17 ରଖିବ?
17
କେବେ 15ରେ ନା 17 ଆପଣ କେବେ କହିବା ରଖିଦେବ କେବେ କୁହନ୍ତୁ ଆପଣ 15. All right, put up this matter on 15th of September.
Item 9.
The self-certificate has been issued on 19/6/2025 and the possession has been
In view of this statement given by him, that it has already been sold, we have no knowledge, and the possession has been delivered. So liberty can be given to us to approach the DRQ.
Can you tell the name of that person?
I have already given.
Because he is not having the knowledge that is.
Yeah, he already given the.
Because he has to argue as a party.
That is not complete. That is not complete. No plot number, nothing is there. हाँ,
ସେଇଟା ଦେଇ
then you give me a copy.
କାହିଁକି ନା ତାକୁ ଆଡ୍ କରିବେ
ଆମେ ତାଙ୍କୁ
copy
detail
note
କରିବୁ।
ଥିବ, ହଁ। All right. Mr.
ठीक है
Anjan Kumar Biswal and counsel appearing for the bank submits that the auction sale, e-auction sale has been successful and sale certificate has been issued in favor of the successful bidder, namely Vishwambar Das, and possession of the property has already been handed over to him. So, in view of such submission made by the land counsel for the bank, Mr. Mishra and senior advocate appearing for the petitioner submits that since the alternative remedy is available to challenge the
sale and possession.
Sale and possession given to the successful bidder, he wants to withdraw the writ petition to approach the appropriate forum. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to seek alternative remedy in accordance with law. It is made.
If you refer the judgment also that
से judgment गुड़ा को सब refer कर देवे जोड़ा को सब अच्छे होते हैं अरे बापना केस
And why don't you give the detailed address? We will write it in the order itself. You need not communicate it. Entire address, father's name, address, everything. So we have लिख दिले आप लोगों को
Plot number नहीं ना.
in the order we will reflect the name of entire.
got a copy Mr. Mishra
order mention कर दोगे
से पूरा नाटा लिख दे नाटा उतर जरा
Father's name, so we address it.
सेल सर्टिफिकेट मिडिल फोर्थ लाइन रे अछि तार
अच्छा अपन फाइल करछन सेल सर्टिफिकेट अच्छा he has filed also the sale certificate which is taken and the possession also. Yes. Next.
Item 10,
Then Mr. Panigrai, where is counsel for the petition? You are for the.
You go to the single judge.
What do you say?
Your Lordship, my humble contention is that the present
No, let the registry place a note because it appears that it is a single judgment matter. So, Mr. Ramchandra Panigrahi, Land Council appearing for the opposite party submits that in view of the nature of FRAIA made in this writ petition, the matters is to be taken up by the land single judge of this court. Let the registry examine the same and place it before the appropriate bench. Land counsel for the petitioner. Madam, your name is?
Shweta Senapati, Your Lordship.
A. Senapati is present. All. Yes.
Your Lordship, can I make a simple player, Your Lordship? Because we are under the impression that they would issue a auction notice. Just till the next date, can I get protection? Just till the next date, Your Lordship.
No, it will be placed before the DR today itself and let him examine and he will place a note and it will be listed during course of this week. Okay? Yeah, next.
item 11,
Mr. Patnaik. He na kon aschi Surya Narayan Patnaik.
Yes.
Now your name will be reflected. Okay. Yes, so what is this matter for? You come to the order dated 3/9/2025. And please place it. Just keep it in mind the date of the order, yes.
The result of reconnection conducted for suspension from the authorized and administered work, the digital channel will be declared within a fortnight. Project area, the basis of the merit which the appointment order, appointment order will issue as a period of 1 month. If there is no other legal authority, the income order reflects in para 4 that after the start of notification has been given upon the state, so neither counter has been filed nor an instruction were received from the authority concerned. When we dispose of the, when we put a pertinent question to the Learned Council, why there was enough for the good and date, content itself were also filed by the party, for implementing the they para 9 and 11 of the restriction, but in appointment will be taken, but in what within the case of the petition that is the imposer has been often like very fraud on the court. The petition was convicted to them, and therefore the matter is taken up on the confiscation of 126.
We posed a question on that day that when you are raising a point that fraud has been committed and the order has been passed, so in such a case the duty is to first place the matter before the concerned court, before where the alleged fraud has been taken. You have not done that.
The review was filed on that.
No.
Review was filed on that.
You are
Review
not-
was also dismissed.
Yes,
Review was filed.
yes.
The review was also dismissed.
Where is the review order? You are only challenging the order dated 23 to 2015.
That's why they.
Then,
Yes, that-
if the review order has been filed, that should have also been challenged.
That's why today I was, subsequent order is required to be challenged.
Are you sure the review petition has been filed? अरे थरू थर गोटे गोटे प्रकार सबमिशन कले असुविधा होची ना लिखंतु
रिव्यू रे फ्रॉड ग्राउंड नहीं चंदी
तो रिव्यू पिटिशन देबे रिव्यू रो ऑर्डर टा देबे लिखंतु
Objection was not over by that.
and because you see
10 वर्ष डिले रहनी आउट रा एमती करी करी आउट 15 वर्ष नेबे
no, it's all right, but question is that in the writ petition itself you have not mentioned that any review petition filed and that was dismissed.
Review person can
Who file कर दिया mention कर दिया.
is this review annexure 3 is the review petition.
Yes. Not passing on, sir.
Where have you stated that against that order which you are challenging here, that is 23 to 2015, you filed the review petition and when it was dismissed, where is the averment? Let us see. Para 7. You come to the particular line which I want to see. Paragraph 7 is like misinterpreting so on.
Page 7, para 7. That the petitioner has not taken any step to file any review or content.
So?
However, to file a review petition in the main case of separate officers and state of Orissa, some subsequent case. Next slide. Which became the decision is present in order that review petition dispute on 17/2017. The present petition also challenged both the original order and order passed in the review petition in the separate petition. The subsequent 11 that both the order of
Okay, chale.
Which one?
the second item.
The second item.
Item 11.
Is that review order is challenge?
Just a minute, let us see. So this matter, acha, 8 plus 8 को एकटी सुनानी होती अच्छा. So, but somebody else is there. It is Supriya Pati. It is one of Satyanarayana Mishra लिखरानी. Mishra, no, similar name. 8 uchi. We are asking. Please answer. This writ petition. The original application number is in this case is 34.
3547.
Where have you, referred the review petition number, which is the review petition? Copy. Seven zero order kind.
Sir, order to 4 weeks. 4 weeks, na? No, 4 years. Next 4 weeks.
Lecture 4.
ସବୁଠୁ ଉପରେ ଅଛି RP number 7C, ground 16. ସବୁଠୁ ଉପରେ ଅଛି.
The review is dismissed. So that order you should have challenged also. Okay,
That review petition was dismissed on the ground of delay. Hopelessly time part.
we are asking you, because in this case, it is individual question of individual case. Now, so far as this case is concerned, you are challenging annexure 1, the order dated 23/2/2015, and that order is annexure 2. Against annexure 2, you filed the review petition, that is annexure 3, and the order was passed in annexure 4. But in the prayer is completely silent. In the prayer, there is no challenge to the review petition order. The Learned Counsel for the Mr. Aurobindo Mohanty, Learned Additional Standing Counsel, submits that though in the writ petition, challenge has been made to the order dated 23/2/2015, passed by the Learned State Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 3547(C) of 2014, which was filed by the opposite party, Supriya Pati. But after the order was passed, a review petition was filed by the petitioners before the Learned Tribunal, which was numbered as RP number 17C of 2016. And the copy of the review petition has been annexed to the writ petition as annexure 3. And the review petition was dismissed by the Learned Tribunal as per order dated 17/5/2017, and the said order copy has also been annexed as annexure 4. However, inadvertently, in the writ petition, the order dated 17/5/2017, passed in RP number 17/6 of 2016, has not been challenged, and he may be given some time to amend the prayer of the writ petition by filing necessary interim application. By filing the interim application, put up this matter on Keberokua Count. So it will be on 22nd. List this matter on 22nd September 2025. If in the meantime any interim application is filed for amendment by the petitioner, the same shall be listed for orders. Stop. Mr. Mohanty submits that the name of Mr. Surya Narayan Patnaik. All right. that his name may also be reflected in the cause list. The name of Mr. Aurobindo Mahanti, ASC, shall also be reflected in the cause list along with Mr. Suryanarayan Patnaik, AG, right? All right.
Item 12, you have not filed review petition now. No. No, but you have not filed review petition.
The main case order was passed. All of the OA was disposed of, similar matter disposed of.
But here nothing, you have not said anything. In yeah, review
as a review petition. To take instruction whether any review petition has been filed or not. Okay, because again, this is let's undo. Other kichi order is the same order to each of. Where government has been to explain the work. Land Council is a second Land Council for the
dispose of annexure 2. Annexure 2. Similar matter in respect of publication. Item 11 को rely करके by force करके इधर dispose of कला. कला पर आप review file करेगा तो ये order चलेगा करके इधर नहीं हो रही है.
ये order था उसी 2015 पास ही.
इधर पहुंचे relying upon that earlier.
इसका को नहीं जल्दी नहीं देखी तो instruction दो. The Land Council for the state seeks for an adjournment to obtain instruction as to whether any review petition has been filed challenging before the Land and State Administrative Tribunal, challenging the order dated 17/3/2015, passed in way number 800 of 2015 or not. Stop. Put up this matter on 22nd September 2025 with WPC number 24064 of 2025. Item number 11. The name of Mr. Mahanti, Aurobindo Mahanti, ASC, shall also be reflected in the cause. Yes. Dita का 22 नोटिस है ना.
Item 13.
Mr. Patnaik. Item number 13.
Yes, madam.
Yeah. Smita Ranjan Patnaik, sorry.
Auction notice.
29th August 2025 for an amount of rupees 18,57,000.
ना कोई करिएगी bidder, successful bidder. Ma'am, to go to the challenge it before the alternative remedy is now available.
And the auction date was 29/8/2025.
Yes, it has been successful and the successful bidder has come. You have to include him as a party and alternative remedy is there. So we are disposing of giving liberty to Lekhan. This writ petition has been filed challenging by petitioners so and so, challenging the e-auction sale notice dated 12/8/2025 under Annexure 1. Stop. Mr. Tunasau Land Council appearing for the bank submits that the auction was held on 29/8/2025 and it has been successful. He further submits that the petitioner can approach the DRT if he so likes, if they so like, challenging the e-auction sale notice as well as the sale. Law is well set to further resolution in view of such and such days without expressing any opinion on the merits of the writ petition. The petitioner writ petition is disposed of, giving liberty to the petitioner to 6 months. Yes, next.
I am not lording on divided property.
Raise all those points before they are yes.
But my daughter.
Yes, next item.
Because we are not entertaining your petition.
I stay in residential house.
Go and
outside.
file an interim application.
File immediately.
File immediately.
File immediately, you'll get interim.
Yes, next.
Item 14.
14, my lord, yesterday night I received a caveat notice issued by
Yesterday?
caveat.
Yesterday.
That is one Shiv Prasad, Shivadatta Ram Prasad Mishra. Serve the copy to.
They are instructed me to appear, okay, because another matter is there, in court number 6, there I am appearing in the same.
Have you served a copy on that?
My lord, yesterday night I got the caveat.
Acha, caveat petition, it's a caveat to asini copy.
नंबर भी पढ़ी नहीं सेमती पठे दीजिए ना
अच्छा लिखନ୍ତୁ नहीं ठीक है ଆପଣ ରଖନ୍ତୁ Mr. Mishra Land Counsel for the petitioner submits that yesterday he has received the copy of the caveat petition but the number of the it has not been given. Stop. The office will verify whether any caveat petition has been filed. And if so, the same shall be also placed along with the writ petition on 15th of September 2025. And in the meantime, the Land Council for the petitioner shall supply a copy of the writ petition to the Land Council for the caveat.
Lord, may I pray you one line? Another is single bench matter related to this matter. That is WPC 9483 of 25. You kindly for reference. One WPC 9483 by 25. A single bench matter in related to this loan amount, loan account.
Let the caveator come and let the matter be listed. We'll see that on that. We are listing it on 15/9. On that day, we'll see that. Yes. The name of the Land Council for the caveators are also be reflected in the positive. Yes.
Item 15.
Yes, Ms. Mahaprabhu.
Case where the culpable exercise of arbitrary power that the petitioner while continuing as office superintendent, and that means establishment officer reverted to peon, my lord, class 4 without initiating a departmental proceeding, a major punishment from level 5 to level 1.
You want an order for expeditious disposal?
No, my lord, I want that status quo. I am a senior clerk. My lord,
have you
kindly see, my lord, that one document.
Have you moved any application before tribunal which is rejected?
Yes.
Where is that order?
My lord, that is, they have stated that, my lord, because of malified purposes, I have to make him by name, that officer to the party.
You are praying to pass the order dated 28/2025. You come to that order under Annexure 7.
My lord.
Where it has been rejected.
No, my lord, that is, I issue notice to private respondent number 5. My lord, private respondent number 5 who has already filed count.
The order ta kote quas kon hobo?
Because, my lord, they're following the procedure which is contrary to the central procedure rule. In central, we file the requisites at a time all the notice issued. When it is admit, my lord.
We are not going
to. What is the writ? How can you, this order is amenable to writ jurisdiction? You have to point out to that court, you are not following right procedure.
That I have, my lord, submitted. I, my lord, want that senior clerk they have set a status quo.
Nothing has been decided here. Is just notice has been issued.
Because
no order has been passed against you. So why is the question of entertaining this writ petition?
My lord,
have you moved an interim application for status quo?
Yes, my lord.
It is pending. It is pending.
No. That has been disposed of by that order.
Where is that?
My lord, MA number Annexure 3, page 54. MA 328 and 292.
Where is that order? That's what we are asking. Where is that order?
That order they have passed in my MA.
Where is that order?
That would Annexure 7. That is the order, my lord. So
Annexure 7, nothing is mentioned here. You please read. This is just 3 lines.
That, my lord, kindly see that they have not.
Are the Land Council?
MA number is there.
MA has not been disposed of, madam. We are repeatedly asking you where it has been disposed of.
No,
only the counter is sought for.
No, my lord, MA number is there. In my MA, where I have filed a case for.
Apana MA file kale, MA ta dispose of kodi hela mo. MA re kodi order ta pass hela.
ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
ସେଇଟା ତ ଆଜ୍ଞା ଦୁଃଖ ସେ କିଛି କରୁନାହାନ୍ତି।
ସେଇଆ କୁହନ୍ତୁ।
ଗୋଟେ ମିନିଟ ମତେ ଖାଲି ମୋ ଗୋଟେ MA ଆପ୍ଲିକେସନ ଟା ଦେଖନ୍ତୁ ଫାଇଲ କାଉଣ୍ଟର।
No order has been passed. We are not going to entertain this.
My kindly see page
This
69.
petition has been-
We'll simply say we'll expect that the MA will be disposed upon it.
But that is the problem, my lord. They are saying that counter is filed. I need a order only that I am a senior clerk and I am
No
promoted.
question of it. Matter is pending here. Why will pass the
Culpable illegal
filed,
order without initiating a departmental proceeding, they have reverted me major punishment.
order dated
And they are not.
2025 under annexure 7 on perusal of the same.
There is an MA, my lord.
That this said order has been in the said order. Notice has been issued to respondent number 5 and the matter was directed.
Was already filed counter.
On 25/9/2025. Therefore, there is nothing in this order to be interfered with. Writ petition stands dismissed.
Already filed counter.
Yes, dismissed.
Again, they have filing, my lord.
All right, next. Yes,
My lord, respondent have already filed the counter.
all right, let him file that. Yes.
You are at liberty to move application for court.
Yes, item number 16.
Item 16.
That's the reason why.
Yes, item
16 may-
16.
May I please, your lordship, item number 16, your lordship.
Then,
And let me kind of a glance on order dated 1st August 2025, my lord. The direction to take instruction in regards to the correct address, my lord. So far as my instruction is, but the address is the correct, my lord. Can I pray for special messenger, my lord? So far as the notice is concerned, the address cannot be located, my lord. So can I pray for the special messenger?
one A and one B.
My lord. Legal are the receipt
One
property.
A टा होशी की कहीं से
My lord.
just a minute. One A टा की one A रो कहीं से
One of the pay.
but the
Amended being.
amended
मैंने आईए नंबर जो सब्स्टिट्यूशन और अबेटमेंट में फाइल है सेकरे सारा
वो सही तरह जाएगी
आगे।
एटा अलाउ ही नहीं पड़ता
अलाउ ही नहीं।
अच्छा
ऑफिशियल
वन A रो ना कहीं देखी कोड
आगे पेज 3 अछि आईए नंबर 152 रे
152
152 रे लास्ट को अछि शेड्यूल ऑफ पर्सन्स
one A ना होची निरंजन कौन
निरंजन जेना
नहीं नहीं
निर्झरणी जेना और सत्यप्रकाश
Chirani
जेना
Jena, a daughter of late Swanso, house number Swanso, Satyanagar, Bhubaneswar Swanso. तापर होची सत्य प्रकाश जेना Swanso. Address very clear अछि. आप postal गले जे एमती या कोनोसी लोक को रहना. Do you want to take notice by special messenger?
आगे
All right, take notice. The London Council for the petition submits that he has taken instruction. Eta likhi हुए IN number 150
52
52 of 2025. है ना?
तीनटा 152 153 and 154
अच्छा ये तीनटा को लिख दें 152 by 25 oblique 153 by 150. That notice has been issued in all these three matters.
this is
That the address of the opposite party number 1A and 1B as given in IN number 152 of 2025 in the schedule are the correct address, and she may be permitted to take notice on opposite party number 1A and 1B to special messenger. Let the office assess the special messenger cost so that the deposit can be made by Friday. You make the deposit. Matter be placed on 22nd of September 2025, fixing a returnable date for the one, and matter to be placed on 22nd September 2025. Yes.
Item 17.
In 17, the eligibility erroneously in the order
Cost
that
cost to be assessed by tomorrow and the deposit is to be made by the after tomorrow. Hello? Matter. Yes, next.
in 17 it has come for correction because your lordship in the place of Binod Chandra Rath, it has been mentioned as Das. First order your lordship will see 433/2025. It was correctly mentioned. But the disposal order 47/2025, the cost title has been erroneously indicated while uploading the order.
Okay.
Not in the writ petition or anything.
No. The office has pointed out that there is a typographical error in the name of the petitioner. Stop. The name of the petitioner is Binod Chandra Rath, but in order number 2 dated 4/7/2025, the name of the petitioner has been mentioned as Binod Chandra Das. Stop. The correct name of the petitioner we reflected, and another order dated 4/7/2025 correcting the name of the petitioner be uploaded, and the earlier order be taken out. In place of the earlier order, it may be. Yes.
And may I pray urgent copy of that order?
Urgent
again,
certified copy of the order.
4/7/2025.
Urgent certified copy of the order dated 4/7/2025 in which the correct name of the petitioner is reflected shall be handed over to the Land Council on proper application. Yes.
Grateful, Mayor.
Item 18.
This is a matter where I am challenging the order of the learned tribunal that rejecting the selection of 53 53 posts to the
Just a minute.
train manager.
Just a
Right.
serial number of the order dated so and so is typed as 2 instead of 3. Sure.
Where the my lord, selection is as per the rule and there is a fair transparent procedure.
আজি जो order টা করিবে সেটাকে number 4 করে দেবে, হ্যাঁ না? Order number 4. লিখি দিও খালি. The office has pointed out that the order number order dated 8/9/2025 should be order number 3, but inadvertently it has been typed as order number 2. Stop. The order dated 8/9/2025 shall be read as order number 3. Stop.
My lord, this is a matter where we are challenging, I am challenging the order of the learning tribunal that at page 147 where the selection process for
Why it has come for orders?
Orders, my lord, because in the meantime, while it is pending before this honorable court, the authority has already issued another notification.
No, as we find that on 4/6/2025,
My lord.
notice has been issued on the question of admission.
Yes, my lord.
And the Union of India has also
My lord, my lord,
represented the council. Now have you filed the counter affidavit? କହୁନାହାନ୍ତି ଆପଣ ନୋଟିସ ଆଡମିସନ ହେଇଯାଇଛି ଆପଣ କାଉଣ୍ଟର ଫାଇଲ କରିବେନି ନା କଣ? ସେଇଆ ତ କହୁଛନ୍ତି ଆଉ ଆପଣ ଏଟା ଅର୍ଡର୍ସ ରେ ଆସିଛି ନା କାରଣ because he is pressing for stay.
କାଉଣ୍ଟର ସେମାନେ ତଳ କୋର୍ଟରେ ଦେଇଛନ୍ତି।
The order has already been passed that any decision taken in the meantime shall be subject to the final outcome of the writ petition. Once you file the counter affidavit, it can be adjudicated finally. So how much time you say?
I have annexed the counter, my lord.
Counter affidavit file କରିଛନ୍ତି?
ଓ ତଳେ ଓଏରେ।
ନା ଓଏ ନୁହେଁ ମ।
ଏଇଥିରେ ଆଏରେ।
ଏଇଠି
ଲେଖନ୍ତୁ। The Land Council for the Mr. Manoj Kumar Poti, Senior Panel Counsel, ठीक तो Senior Panel Counsel, seeks some time to file the counter affidavit. केबे कुहतु आमे रखी दबो। You will file the counter affidavit by 19th. Acha. Submit that the counter affidavit shall be filed by 19th of September 2025. Matter be placed in the week commencing from 13th of October 2025. Yes. I already put order passage. I will repeat.
Why there is one notification कर दीजिए.
Kuda?
ये जो fresh I have filed, that is a fresh notification they have come up. Even there is pending on 26/8/2025, my lord, Annexure 7 to my IL. That is in Sambalpur division. They have advertised already for the same post.
So
that is also
same distance.
Goods train manager. That's why this post vacancies.
Have you given a copy to the
Yes.
interim application?
My lord.
I a copy पाइचंदी. पाइचंदी ना नहीं.
हाँ देची.
या वो stay petition file करती the you have given the copy?
Yes, I have given the copy.
Acha.
For his convenience, I have given
The
a
IA number 4, so and so, the land council for the land and senior panel council submits that since he is not having the copy of the interim application, which is stated to have been served in the office, he is to verify and also obtain instruction on the interim application. Yes.
Item 20.
And I am for the petitioner on behalf of Mr. M.K. Mishra, Senior Advocate. Now, let's sir is in accommodation. Matter to be taken up after 15th of September.
15th of
September.
who is appearing for the other side? Ura Weaving Center. What is your name, madam? So and so appearing for submits that Mr. is senior, her senior, Mr. Mishra is on accommodation and the matter may be taken off a week after. So and so is also present for the opposite party. Please this matter on such and such date.
Item 21.
Item 21, Mr. Dora.
Item 21. On behalf of Mr. Senior Counsel, Mr. J.R. Dora, Your Lordship, I'm placing the written notes of argument.
Which for the other side? Pleadings are complete.
Your Lordship, pleadings are complete, Your Lordship. Written notes of argument already filed here. I'll be placing the written notes.
Are you going to argue the matter?
May I please?
What is the written note of argument?
Lordship, written note of argument dated 22/8/2022 year. So 2/8/2022 year.
You are having that written note of argument. Why don't you give a copy to the state council? Huh?
One minute, which is one thing possible
No, we are not. We are because he wants the final disposal. He might not be pressing for those miscellaneous applications. So now the thing is that he has filed a written note of argument. You please go through it and we will serve a copy.
It is a part of the court.
during the, because in his case he has filed, it's all right, but he might not be now interested for the placing this miscellaneous. So, what is your good name, Learning Council?
Lakshmikant Tripathi.
Mr. Lakshmikant Tripathi and council submits. You are an associate of Mr. Dora. Your name is not there, so that is how you should file some
I'll file it
appearance
today.
memo or something like that. Submits that because none of the, there are 4 names here, 3 to 4 names, none of them is appearing. So you are saying that your so senior has instructed you, but you file the consent memo or the appearance memo, whatever it may be.
Today I'll file.
With the, if your senior permit you, that then so a written note of argument has been filed by the petitioner. It appears that a written note of argument has been filed by the petitioner. However, the land council for the state submits that the copy of the written note of argument has not been supplied to him. Mr. So-and-so submits that during course of the day, such a written note shall be handed over to the land council for the petition. Put up this matter on such and such day for final disposal.
It was filed on 2/8/2022.
Yes, sir. What's your date when filing?
You'd see it in the evening. ସବୁଦିନ ସନ୍ଧ୍ୟାରେ ଅପଲୋଡ ହେଇଯାଏ ଅର୍ଡର ଗୁଡା ତା ଦେହରେ ଆପଣ କାରଣ ଡାଏରୀ ଦେଖିକିନି କେତେ ଦିନ ଇଏ ରହୁଛି ସେଗୁଡା ହେଲା। We are just coming within.
Item 22.
22, my lord. The last two items, WPC OA 1120 and 20 of 2017 and WPC number 5743 of 2024, those two matters are single bench matters for service matters. Those two are to be retagged, my lord. After abolition of the administrative procedure.
1120 of 2017.
Malak, and 5743 of 2024.
What is the nature of prayer in that petition? Let us see.
Yes.
It's not challenging any order of the passed by the tribunal or what?
No, Malak. Those are challenging the relief sought for is direct the government respondents to fix the seniority of the applicants in the cadre of OTAS Group B against the recruitment year 2011. Direct the government respondent to place the applicants above the promotees stroke selected those who were recruited from 2012 to 15. And direct the government respondent to publish the gradation list of OTAS Group B officers cadre, placing the applicants above the selectee.
No, whether the other matters have got any connection with this one, it is totally.
Those matters already in favor of the applicants, the order has been passed and state has challenged. This is similar to that. But however, the last item, that is the 2024 item, that is challenging the gradation list, which is subsequent action, and that is different from these connected matters.
So then only one matter will be examined by the registrar.
It can not be that, but the 2024 matter has to be.
What do you say, Mr. Nayak?
That is single 5743 of
he is a single judge. 5743 ta mark karo. The prayer is to quash the disposition list under 16 and लिखी दियो तो इधर item number last item था WPC number 5743 of 2024. The petitioner Vijay Kumar Naik has filed this writ petition with following prayer, quote the prayer. He submits that in view of the nature of prayer, the matter is to be adjudicated by a single judge. Matter be placed with the registry to list this matter before the appropriate. Enough? Yes.
But the main case is concerned, my lord, state has filed this case. My lord, I see some time, my lord. I have to run through the phenomenon of
You see, matter there is no pass. T3 2021, 2024. There is an order. This is the order, which is that similar, so therefore it is to be listed. Read out the issues also.
No, this
What is
case
to find out?
But after the disposal of
await the outcome of
that would be the outcome of this division bench. So, but we cannot take up this.
Yes,
also. Ready? Yes. Mr. Nayak, what do you say?
Lord, I seek some time, my lord.
Pleadings are complete in this?
Yes, sir.
Who is appearing for the other side?
Senior advocate, past matter, senior advocate, Mr. Ramakant Mantri.
What is this matter all about? Mr. Tripathi, you are also there?
Well, I am for the intervener.
Okay.
It's a case of seniority, determination of seniority in OS cadre, OFS cadre, I'm sorry.
What order you are challenging, Mr.
Order passed by the tribunal, that is at Annex of 6 matter.
Annexure 6? No, it is from the WPC. Order passed by the London Tribunal dated 21/2014.
Annexure 3.
Annexure 3.
Annex of 3 and 6. Annex of 3.
It was that original application was filed by one Vibhu Prasad Mishra, who is here the opposite party.
My lord.
So what is the operative part of that order?
Hello.
You come to page number 94.
Call for a review DP.
In view of the above, just come to that
Madam.
paragraph.
In view of the above, respondent authorities are directed to convene a review PPC for consideration of the case of the applicant. If he comes within the zone of consideration in respect of the remaining 58 vacancies, along with other similarly situated persons belonging to Orissa Subordinate Finance Service cadre or SCPO, as per their ratio and for their promotion to cadre of Orissa Taxation and Account Service within a period of 2 months from the date of promulgation of this order, if this decision of DPC court in favor of the applicant give him promotion from the date of the candidate who were promoted as per the recommendation of the DPC dated 22nd December 2012. However, it needs not be said that since the applicant is not working in the promotional post, even though his seniority will be counted along with others who were promoted as per the recommendation of DPC dated 22nd December 2012, he shall not be entitled to any financial benefit for that period.
What happened? Whether a review DPC that was to be convened, whether any order was passed by this court staying that order?
This is first time listed. I have not often.
No, whether is there any stay of this order?
Because otherwise it was a matter of the year 2014. And the time limit has also been fixed that what you are to do, and you are to within 2 months. So if there is no order, any content petition was filed or what?
No, it's 24/11/2014. Your lordships have stayed the.
Oh, I see. Sure. Then it's
Stayed the order.
So what is the illegality in the order, according to you? What are the grounds on which it is stated that a review DPC is to be constituted and he has to consider all the cases. So what is your grievance? If they are not, ultimately, if they will not be found suitable, this matter is different. But what would be your grievance on this type of order which has been passed by the London Tribunal?
It was listed yesterday night at about 10:30. I received good time.
Achha, you have not gone
I have
through.
not.
So when do you want?
You have already displayed
Yes.
the cause of adjournment.
No,
By
yes,
showing
I
to
will- some other files, sir. Also.
ପୁଣି ଶୁଣାଣି ହବ ନା ନାଇଁ ପୁଣି
One is
beneficiary of that order.
2014 ମସିହାର ଅର୍ଡରଟାକୁ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି we are in 2025 ଆଉ କେତେ ଆଡଜର୍ନମେଣ୍ଟ ନେବେ ଆପଣ ଏଇ ବର୍ତ୍ତମାନ ଯୋଉ ଆମେ ଅର୍ଡରଟା ପାସ୍ କରିବୁ that would be order number 28 ହେଲା ଓ ତାମାନେ ଜଣା ପଡିବ ଯେ ଆପଣ ପାଖାପାଖି 27ଟା ଖଣ୍ଡେ ଆଡଜର୍ନମେଣ୍ଟ ନେଇଗଲେଣି ଆଉ ଯାହା ancillary order ପାସ୍ ହେଇଥିବ.
In the meantime, many people might have been superannuated.
Because you are now enjoying
10 years.
interim order and why are you depriving the persons
I only
who
next
might be
week.
entitled to get the promotion? So,
You are waiting till all of them are retired. Then you will go.
ତାଙ୍କର ଏଜ୍ ବର୍ତ୍ତମାନ ସବୁ କେତେ ହବଣି? ଇଏ ୟାର ତ 40 ବର୍ଷ ହେଇଥିଲା 2014 ବିଭୁ ପ୍ରସାଦ ମିଶ୍ରର। ତା ଏଜ୍ ତ ବର୍ତ୍ତମାନ ଆସିକିନି ଧରିବଣି 51 ହେଇଯିବଣି।
Person I am representing, he at least must be now 53.
ହଁ ସେଇ range.
All are continuing, my lord, but it's a case of the deprivation of promotion.
Promotion, that's right.
That is exactly what.
Last 10 years, man.
They retire in the same post.
And the order has been passed that they will not be entitled to any financial benefit. ଯଦି ସେଇଟା ସେତେବେଳେ ହେଇଥାନ୍ତା ଯୋଉ 10 ବର୍ଷର ଯୋଉ ଦରମାଟା ସେ ପାଇଥାନ୍ତେ promotional, now they will be deprived because the order is very specific and they are not challenging that order. The operative part of that order is, if you just read it out, that someone a financial benefit is paiveni.
However, it need not be said that since the petitioner is not working in the promotional post, even though his seniority will be counted along with others who were promoted as per the recommendation of the DPC dated 22nd December 2012.
Why don't you hold a DPC and keep it in seal cover? We'll see. At least one step should go ahead.
My lord.
That we can see. Keep it.
2014 ରୁ ଆପଣ DPC କରିନାହାନ୍ତି in spite of the order of so and so.
Contact a DPC.
The stay order to achieve it.
No, that we will modify that.
Modify କରିଦଉଛି.
We will modify that. You contact the DPC. Don't publish the result. We'll hear it. At least one step we should go ahead. Why to completely stall is very, to that extent we will contact the DPC. At least they will have little hope.
The Mr. Naik, Land Additional Government Advocate 6 for an adjournment. It appears that the pleadings are complete. The impugned order was passed on 21/1/2014, and in the operative part of the order, it is observed as follows. In view of the evidence of the law.
94, 95.
94 or 95. It appears that when the matter was taken up for admission on
24/11/14.
24/11/14. প্রথম অর্ডারটা 24/11/2014, and as an interim measure, an order was passed that there shall be stay of operation of the order dated 21/1/20, passed in way number so and so till 31/1/2025. The interim order was extended from time to time. The Land Council for the opposite parties submits that most of the opposite parties are now crossed 50 years of age, and in view of the interim order passed, the DPC could not be held, and therefore the matter requires early hearing. Since 27 adjournments have already been taken, we modify the interim order dated so and so forth 24/11/2014 and direct the petitioners to hold the DPC on ସେଟା କଣ word ହେଇଥିଲା use ହେଇଥିଲା review as per the order dated so and so, and the result be kept in sealed cover. Matter will be
1 month. Do it
within 1 month, and matter will be listed in the week commencing from 13th October 2015 for final disposal, and ତା ଭିତରେ ପଡି ଯାଉଛି ନା ଗୋଟେ ମାସ ହେଇଯାଉଛି. The Land Council for the state shall apprise this court on the next step whether the review DPC has been held in the meantime or not. Yes.
And the result.
Result of our sealed cover.
No result. Only one step.
Yes. And this matter should be listed along with so and so matter. खाली गोटे मैटर बाहरी जीवो से जो लास्ट आइटम लास्ट 5740 टा काटी देबे सेटा को अन्य ऑर्डर कर देबे बाकी सही यस नेक्स्ट
Item 23.
Item 23. Just engage in that matter. But we have to also find the result, find the counter. If the grant rules fixed after the vacation, so that.
You will appear for the appellant.
Yes, sir.
Who is for the respondent, Ms. Mohammed Siraj. The rejoinder affidavit has not been filed and you intend to file it during this period. It is to be listed after, you say that after Puja holidays. What do you say? All right. Mr. Mahanti, land senior advocate appearing for the appellant, submits that since counter affidavit has been filed, the appellant intends to file a rejoinder to the counter and the license may be taken off after ensuing Puja holidays, so that we'll file the rejoinder affidavit in the meantime, giving copy to the land council.
You have already filed a rejoinder. That's there.
Rejoinder?
No, not rejoinder on behalf of the petition.
Not filed.
Not.
Only read appeal, they have filed the counter.
Read appeal.
That rejoinder is a writ petition.
Okay.
This rejoinder on behalf of petition.
It a writ petition.
Writ petition.
But appearing normally counter not necessary, but since they are filed, we have to file it.
Put up
In
this
fact,
matter.
in the writ appeal, you don't need separate pleadings.
Right.
On the basis of the pleading before the single judge, we can decide. Anyway, you want to file.
Land counsel for the opposite parties present. Put up this matter on such and such date. Put date the king.
Okay, sir. 2 days, but of
Yes.
Item 24.
My appearance will be noted with this message.
You are appealing for whom?
Appellant.
Your name is there.
Mr.
Yes, my name.
Saroj Kumar Das name is there.
Yes.
So like Mr. Mahanti along with Mr.
My
Saroj.
appearance has been filed in the.
But whose name is to be dropped from here? Lot of
By
names.
all others name because it is transferred brief to me.
So therefore, all other name has to
Mr.
be dropped.
MP Singh already from EP you are conducting matter and
अच्छा so एगुड़ा ना काटी दो ना
ना काटी दो.
कहाँ ना कटियो कोई होना दी महेंद्र प्रताप सिंह ना
Singh, he
कटियो
have given consent and I have appeared.
अच्छा तापरे मिलन कानून को ना कटियो
Say now कटियो.
अच्छा ये तापरे आउ कार कोन तो आपण को ना एसके पटनायक
And all other SK Panna कटियो and all other.
कटियो अच्छा
All others name will remain.
all will name will go
Yes.
अच्छा लेके जाओ
No, all others remain with me. All others are with me.
अच्छा अच्छा देन को ताले महेंद्र प्रताप सिंह को ना कटियो मिलन कानून
Yes.
को ना कटियो अच्छा the name of Mr. Mahendra Pratap Singh and Milan Kanungu shall not be reflected in the cause list henceforth. That are you WA 615 of 2015 है ना? Yes, item number 24. 24. Mr. Kuntia. Yeah, what is your good name?
My name is B.K. Pondan. I'm on behalf of Mr. Pilochan Nandamala, he is in another group, so.
What do you want?
We'll argue.
Will you argue or adjournment?
You are Mr. What is your name?
B.K. Pondan.
BK Panda. Okay. You want to argue the matter. It is State Administrative Tribunal order has been challenged.
Yes, madam. That is page 80, madam.
Page is?
Page 80 is the operative part, madam. And as for 6, page 81.
No. You first come to the original application. What was the relief sought for before the learning tribunal?
My lord,
Please come to the relevant paragraph of the original application where you have mentioned what is relief sought for.
Yes, my lord.
Page number, the original page is 29, internal page 10, paragraph 7. Are you not having the copy of the original application with you?
That is annexed here, my lord.
You have annexed. That is why we are pointing out that
Yes,
that is annexure 1.
Yes, my lord.
And the internal page is 10, but running page is 29.
Yes, my lord.
Please come to paragraph number 7.
Yes. Page 29, my lord. Relief sought for, my lord.
Yeah.
To quash the order dated 25/8/2012.
What is that 25/8/2012?
On 25/8/2025, my lord, petitioner has been discharged from his duty, my lord.
Okay.
That order is impugned. Page 34, you also make an
34, yes. Please read it out.
page 34, my lord.
Yes.
Dambludhar Bemal, 4th IR.
You are constable number 260
Yes, my lord.
of 4th IR Battalion, Devgarh.
Very good.
Was deputed to undergo.
undergo.
Please read it out.
Was deputed to undergo 80 course.
This has been specified. He has been reinstated. But from the date of discharge to the reinstatement, no salary will be paid. How do we by that? Page 88. 88. 88. Last right. Accordingly, we require an action to
Direct reinstatement. That relief as well.
He will be granted continuity of service from the date of but no salary wages will be payable to him from the date of discharge to the date of reinstatement, as he is worked as constable during the period. His students are devoted to initiate action against the applicant following the process. That part he
So the prayer is now limited. So
your prayer is limited to the extent that salary and wages for that particular period is not given to you, isn't it?
No, my lord. Reinstatement of the petitioner, my lord. Petitioner has been discharged on 25/2012 as the unfit in medical exam, my lord. For 80 course, my lord. Anti-extremist test is a training course, my lord. Petitioner could not complete that
no,
anti-extremist
Mr.
training.
Counsel, the order has been passed and the direction has been passed to reinstate you. So
That is another application, my lord. Page 80 also make an
just a minute.
80.
It is number
80. In your case, 80.
Oh, that is.
Oh, that is another route.
That is another case, my lord.
Okay.
Similar
This is 4274.
Okay,
Acha. Why have you given as an annexure? Because it is in another case, similar case.
Similar to the.
Okay. You want similar order?
Okay.
Yes, ma'am.
Okay. 7980.
I was the applicant in 4274.
So in your case, what order has been passed?
Page 80 is the order, my lord.
80.
Page 80, 80.
Let us see that. Oh, your OA has been
discharged on service, hence the application has been found.
Why it has been done? Why you are discharged from the service?
Because
medically unfit.
I have not completed 80 course training, my lord.
Hence, the applicant has been found to be medically unfit by a medical board.
Yes, ma'am.
And hence unable to undergo specialized AET training, which is required for performance of duty.
Ma'am.
And IRB order 2006 is framed under so and so, and pending training so and so. Completion of the specialized training is also covered so and so, and so do not find. So how can you perform the duty of a constable if you are medically unfit?
My lord, AET training is not a basic course of training, my lord. That is not needed for regularization of service, my lord. You also may kindly see, my service is governed under the Indian Reserve Battalion Service Method of Recruitment and Condition of Service at Constables of Order 2006, my lord. And I have appointed on 27/2009 as constable, and I have completed basic course of training of 9 months as prescribed in the rule of 2006, my lord. And thereafter, I have already completed 2 years basic course of training, my lord.
Acha, this is one advanced training.
Yes, my lord, that is advanced training, my lord. That is not comes under the basic course of training, my lord.
So you mean to say that suppose you are not found to be fit for that anti-extremist training,
Yes, my lord.
then the persons who passed that training successfully, they may get some advantage,
Yes, my lord.
but that is not a ground to totally
Discharge,
take
my lord.
you out of the service.
Yes,
That
my
was
lord.
your ground.
Yes, my lord.
Okay.
What kind of medical problem you have?
After completion of basic course of training, my lord, petitioner undergone a knee treatment, my lord. His knee treatment, that's why he could not complete his 80 course of training, my lord.
Okay.
80 is a specialized training, my lord. After that training, the applicants or habildars, those who are engaged, are appointed.
The standing medical board observed that DT Bimal is having flexion deformity, right knee as on duty, which requires constant supervised physiotherapy, and is declared unfit till the next month. So it is advised to attend the next standing committee for reassessment of the right knee.
Kindly page 71, you should kindly see. My service is governed through the Constable Rules 2006. I have annexed the rules, my lord. Page 71. Page 71, my lord.
No, after this problem arose, whether while during you are on service or initially these things has been suppressed.
No, this thing has not been suppressed, my lord.
Then
When you were undergoing the training, that time this has happened.
No, I have already undergone my training. That's why I'm showing, my lord. Page 71 also may kindly see for a moment. Page 71. My lord, my service is governed through by the Indian Reserve Battalion Service, Method of Recruitment and Condition of Service of Constables Order 2006. That I have annexed, my lord. Page 71 also may kindly see.
71.
The appointments, my lord, 13. Rule 13 appointments. The persons appointed shall be on probation for a period of 2 years, my lord. I have already completed my probation period. Thereafter, 14, my lord, training. A candidate on being selected and appointed as constable, he shall have to undergo training for 9-month duration at designated police training institutions, my lord. My lord, I have appointed in the year 27/2009 as constable, my lord.
27/2009.
27/2009.
You have undergone the training.
Yes, my lord. I have undergone 9 months training.
But it says that if the person is found physically unfit during the period of training, he shall be discharged from the service.
My lord, during the probation period, my lord, and I have already completed my training period, my lord. 9-month training period I have already completed.
Where is that document? You say that you have completed.
Undergo basic course of training with effect from 16/11/2009 to 15/9/2010, my lord.
What is that date chart? We should show that this is the date in this your appointment date is this. You completed this period of probation like this. Then you training you undergone for so and so. You successfully completed. Where is your date chart?
My lord, I have discharged on 25/8/2009.
There are so many dates. Why are you not preparing now the final disposal? You will not prepare a date chart.
My lord, can I have a class 2 wrong page 78, paragraph 5.
Yeah.
Wrong page 78.
Yeah.
On hearing learned counsel for both the sides, we note that applicant was appointed as constable in the 4th Indian Reserve Battalion on 13/7/2009, Annexure 1, with a direction to report by 27/2009. Constable were appointed for a probation period of 2 years with effect from the date of their appointment. Rule 6688 TMF state that during such probation period, authority empowered to take such appointment can remove an executive officer directly appointed or reverted such an officer promoted who was shown himself unfit for such appointment or promotion without showing procedural formalities prescribed under Rule 828 of PMR. As per Indian Reserve Battalion Service Method of Recruitment and Condition of Service of Constable Order 2006, the person appointed shall be on a probation for a period of 2 years. As far as training is concerned, a candidate on being selected and appointed as constable shall have to undergo training of 9 months in duration as
Designated police training
institute and any other specialized training required for the job. As directed by DG and IG of police, if the person is found physically unfit during period of training, he shall be discharged from the service. In case he is declared health in the examination at the end of the training, he will be allowed to one more chance to appear in the next examination without having to repeat the training. If he again declared failed, he shall be discharged from service. Rule 14.3 of IRB Method of Recruitment and Condition of Service of Constable 2011 prescribed probation period of 2 years or till successful completion of basic course of training. However, ATE training is not a basic course of training but an advanced anti-extremist training. As per Rule 14 of the IRB Method of Recruitment and Condition of Service Order 2006, if a person is found physically unfit during the period of training, he shall be discharged from service. Hence, the applicant has been found to be medically unfit by medical board annexure A to the written note of the submission of the respondent, and hence unable to undergo specialized ATE training, which is required for performance of his duty. This IRB Order 2006 is framed under Section 2 of the Police Act 1861 and pending framing of the regular recruitment rule under Article 309 of Constitution of India. Completion of this specialized training is also covered under Rule 14 of the IRB Order 2006. Hence, we do not find anything illegal or irregularity in the order of discharge issued against him.
No, just see, take the dates. He was appointed on 13/7/2009. 2 years expires when?
Yes,
When?
11.
11. When you declare him medically unfit?
25/8/12.
Come to your own document annexure 3 to your counter. Counter. That is on 1/3/2012. You have declared unfit. After the expiry of the probation period,
Yes,
after undergoing 9 months training. That's what his case is.
Yes, ma'am.
Just see your annexure 3.
Yes.
This board, what this board says, 1/3/2012. This is the certificate. By that time, he has already crossed through that 2 years probation and 9-month training. What is your answer to that? And the tribunal only discussed the rules and all. Thereafter, he says medically unfit. When? Medically unfit is 1/3/2012. Tribunal doesn't discuss about anything about his case. Tribunal discuss about the rule position. No doubt, rule position is there, page 80. But when it comes to his case, straight away says that medically unfit. Doesn't say when the medically unfit. His appointment is not doubted. His unfitness is declared when it is also not doubted. Then how will you reconcile these dates?
सीधा कोई देखिए मेडिकल अनफिट
Sir, you have taken the ground that you have successfully completed that probation period and that training in your writ petition?
I will share that in the writ petition or OA.
Or in the OA?
In my written notes.
No. Pleadings.
You just now said that
Page 6, Para 6, page 3.
Please.
Come to page 21, sir.
21.
21.
Yeah.
It's the first paragraph. That the applicant completed the basic course of training in the year 2010 and he has completed his probation period in 2011. And the profitable to mention that here in so undergone the operation of knee in 2011.
So what is your counter to that? Is you where a counter going?
It's here.
Yes, 35.
What is your reply to so and so? Paragraph 6.1.
6.2. The ways applicant was undergoing training at the Care Hospital undergoing treatment at Care Hospital Resettlement 2011 and 2012 for writing post OPSCL as he has advanced to right duty from 1/4/2012 to 25/9/2012.
But by that time, the probation period was over. 1/4/2012 to 25/9/2012. By that time, his probation period of 2 years was already over.
On the next medical board in March for reassessment of alignment.
First March.
In paragraph 4, is AET course is mandatory for Indian Reserve Battalion Constable for completion of basic course of training. Due to medical unfit, the applicant was discharged since he was not able enough to complete the training as remarked by SOG headquarters Chandaka.
No, this suppose somebody is appointed and completes the training probation period and also the training, it's all right, and that he has
also basic training
that he has undergone.
he has
Because-
not completed.
No. You see
Basic
that
training he has done.
for this paragraph number 6.2, specific government is that the applicant completed the basic course of training into year 2010 and he has completed his probation period in 2011. है ना? तापर से कहउछंती जे 2011 ने से अंडरगोन कला जे राइट नीर ऑपरेशन तो ए जो ता पूर्वर जो गवर्नमेंट निहाई there is no challenge to this government. In the counter affidavit it is totally silent that no, he has not undergone even the basic course of training in the year 2010. He has not completed the probation period in 2011. So that is not there. So admittedly, if you are not challenging that part, then the question comes about the other thing. That means that training, what is called SOG.
AET course.
Huh?
AET.
AET course of training. Let us say the persons are the constables are also asked to go their trainings so that they can get some promotional benefits or some higher scale of like that. Suppose for some physical ailment or this deformity, he is unable to successfully complete their training. So the benefits which will accrue to him for that training, he may not get. But how you will throw him out of the service
Once paragraph 4 of the counter of debate, they are saying that 8 course is a mandatory training for Indian Reserve Battalion Constable for basic course.
It is a specialized training, not a basic course of training.
Para 5 of your counter, just see, you have admitted that position. Para 5 of your counter here. In the petition, para 5. Called counter.
Yeah.
Para 5. Date of counter. Para 5. It is humbly submitted that the petitioner was appointed the constable so and so and undergo the basic training for a period of 9 months. And any other special training required for so and so, so and so. You admitted that he has undergone the basic training also. Probation period is over, basic training is over. How will you remove him?
Worry that that those procedures that regulation or rules has been laid down that even if suppose he completes this, that means he is appointed, then he has undergone the basic course of training, successfully completes it, and then the person is also sent for the specialized training. And if he is unable to complete that specialized training, he will be totally thrown out of the service. एमती की चर्ची की अपन करो ये.
And you yourself have said that you have advised for the light duty from a particular. You can continue with light duty with him. How can you remove him?
Question is now it is of removal from service.
Completion of the anti-extremist tactics course under the rules, what it says, can be removed from service.
Definitely, those persons might be getting some extra remuneration and right. Obviously, they have undergone the training and they are taking higher responsibilities, protecting those. So definitely, but you can defray because he has not undergone. So definitely, he will not get that.
Whatever benefit attached to that training, you may not give him, but you can't remove him from service like this.
But if you say that there is some kind of rules, etc., that even if he is constable, that is different. If that is there, it might. But common sense, you said about a specialized training achi, and specialized training for a jane a benefit would paibo. Then the person who is unsuccessful, then he will be deprived of those benefits. But you cannot take him from the service. That is the.
The purpose of this 8 training is, my lord, the persons who complete this training, they will appointed in the Naxalite area, my lord. That is the only.
No, apart from Naxalite, maybe that some kind of extra benefits will be given to them.
That is not comes under the basic course of training.
No, that's we follow it. But what do you say? You want to obtain infection? Because your counter is not in that light. Your counter light that as if that everybody has to undergo that training. It's all right that they will be asked to undergo the training, but for something which has happened during and he is not. So how can you?
The new injury caused during the service.
2011.
During service.
Yes, during service.
There is the Act is also Disability Act is also. Even Disability Act is also protected. Even if he is disabled, you can't throw him.
You can interest some other wars. There are so many constables who can do other light wars. But how can you take him? All right, take down. The writ petition has been filed by the petitioner Damboruzhara Bimal, challenging the order passed by the London State Administrative Tribunal, Cuttack Bench, Cuttack, dated 19/12/2014 in OA number 4274C of 2012. In dismissing the original application, stop. It appears that the original application was filed by the petitioner seeking for the following reliefs. Quote paragraph number 7. Grounds have been taken in the original application that the petitioner was duly selected and appointed as the constable in the 4th IRBN Devgharaha. Devghar. And since the date of appointment, he discharged his duties to the utmost satisfaction of the all concerned. it is further stated that he completed the basic course of training in the year 2010 and he has completed his probation period in 2011. And in 2011, the petitioner undergone an operation of the right knee. Stop. The petitioner was sent for 80 course of training and he was found to be medically unfit.
Medical board, 152.
And on the basis of the report given by the medical board dated 1/3/2012, since he was discharged from the service, which was challenged before the London State Administrative Tribunal. Stop. In the informed order, the London Tribunal dated informed order page number
18.
8880. In the informed order,
Number 73, and 73.
73.
23 to start is the operative part.
80 party.
In the operative part, it is held as follows. As a quote for the paragraph number 5, entirely quote for the Land Council for the petitioner submitted that since in the counter filed by the petitioners, opposite party, before the London Tribunal, it is not disputed
As well as before this.
as well as before this court that he has completed the basic course of training in the year 2010 and he has completed his probation period in 2011. Even if the petitioner could not complete the training of 80 course on the ground of medical unfitness, he should not have been discharged from service. He might not get the benefits which the other person would get after the completion of such course. Stop. The Land Council for the state at this juncture wants to obtain instruction that whether there is any rule or regulation, etc., to show that even if a person who has completed the basic training, basic course of training and also completed the probation period successfully, if he fails to complete the 80 course of training on the ground of medical unfitness, he will be totally removed from the service. Put up this matter on such and such date. The Land Council for the state shall produce the relevant materials on that aspect. Hello? All right. Pre-copy of the order be handed over to the Land Council for this week. Which of the matter we are taking up on Friday?
I have a prayer, my lord. I have a prayer. 27, 28, and 34. I am not well. Can it be taken after a week, my lord?
Just a minute. Which item, Mr.
27, 28, and 34.
Then
28 and 34.
You don't want it on Friday?
No, a week after. Because I am not well.
Take care of senior advocate appearing. In all these cases, you are for the petitioner.
My lord, I am petitioner in 27 and 34. 28, I am opposite party.
27 and 34 is for the petitioner, Mr. Jacob. And senior board submit that he is not well and the matter may be taken up a week after. And in 28 is for the opposite party. Opposite party, can you tell the number?
My lord, the OP number.
OP number.
Whole opposite party.
Whole opposite party. And saying not well and the matter will be taken up. So let it be listed on 22nd then. Next week it will not be listed as you say.
Yes, my lord.
20s. All these three matters will be.
30, only a copy of the documents are from us.
Item number
30.
30. Mr. Pari, anybody is appearing from the
State, that state has filed counter affidavit. We'll solve copy.
who has filed the counter affidavit?
State has filed.
No, also counter affidavit has been filed by opposite party number 1, Union of Mr. Pari.
Yes, my lord.
Item number 30. You are for the opposite party number 1. 30 number tare. And you have filed your counter affidavit. The petitioner's counsel submits that the copy of the counter affidavit has not been served on her. So please serve the copy of the counter affidavit.
Yes, my lord. I asked Mr. Bhukta is there. I asked him
All
to
right.
serve the copy.
Hard Miss
Within
I.
3 days.
Savia, learned counsel for the petitioner, submits that though the counter affidavit has been filed not only by opposite party number 1 but also by opposite party number 3, but she has not been served with the counter affidavits. The learned counsel for the Mr. Pari, learned counsel, Deputy Solicitor General, so also Mr. Mahanti, learned counsel for the state, submits that the counter affidavit shall be served on the land council for the petitioner. During course of this week, we are writing. So
Yes, my lord.
put up this matter on such and such. You go through the counter affidavits. If you intend to file any rejoinder affidavit, you file it. It will be after, obviously, after Puja holidays.
Item 32 minutes.
Yes.
Item 32 minutes.
Yes.
In this case, I am for the respondent of 1 minute. But in spite of your lawsuit's order, we had all the referral benefits have been stopped.
We are taking up these matters day after tomorrow. All these matters which are left out, we take up day after tomorrow. Because tomorrow it's a different bench is there. So we take up. No matter will be taken out of list. So all these matters.
Orders no,
we cannot say that.
State a Thai agreement or don't answer.
We'll see that on.
We are providing the counter.
Can I make a decision? These three applications matter, all in all cases, more than 10 years in custody matter.
Lordship, I mean, pardon to make a mention, Lordship, that advocate the criminal appeal, IA for bail, LCR has already been received. I make mention from the item 21, IA for interim, on behalf of simple task number, IA for interim, the condition of the appellant is serious.
So why is making mention? Are we not reaching item number 21 today? Why are you making this one? Yes, call the law.
Supplemental list, item number 1.
Yes, item.
No. So far as my lordship, first item is concerned WPCRL 395 of 2013, that is Charuchandra Parida. Earlier, my lordship, this matter with similar issue has already been dealt with and it has been disposed of. And Charuchandra Parida in the meantime is dead. And he has already been convicted and confiscation order has already been
This is against confiscation.
My lord also hearing that matter.
No, this matter, he challenging the confiscation proceeding of the year 2012. Now you mean to say that the confiscation proceeding has been finally adjudicated. So it has become infructuous.
Yes, ma'am. And also earlier they have also challenged on the same ground which has already been disposed of.
Where are you? Confiscation the ita. Or confiscation of final good. Thanks, sir.
Data appeal pending.
When the date of order, confiscation order.
Date of order mobile.
The petition was for it is a conviction each.
Yes.
So and so. It is Quebec order.
CRL 681 of 2017 pending.
Against the confiscation.
Confiscation.
Acha.
Yes, final order against.
ATV दिया है जे confiscation case number 2 of 2012 is pending. Be concluded in accordance with law. It is 2021 order. तब conclude के बेला.
My lord, so far as against final order of confiscation, CRL 681 of 2017 pending.
Yes, sir.
CRL 681 of 2017.
High Court. आपण परा 2021 मसियारे देखौचन confiscation pending अछि बेली आ 2017 रे केमति final order pass हो
नहीं 17
interim order ହେଇଥିବ
कोड नहीं
ଏଇଟା interim order against ହେଇଥିବ
नहीं final order तो दी टांगर हे जाई because my lord was hearing that matter also where
our case has not been final
नहीं चारुचंद्र परिडा केस रे से मरि जाइछंती
we want two things, that the confiscation case number 2 of 2012,
yes,
whether it has attended finality or not, because if it has attended finality,
yes,
then the appeal lies here. So there are appeal can lie also against the interim order also.
Yes.
So the matter which is pending before this court, whether it is against the final order or interim order, you show that provision.
Yes, sir. My lord is correct.
That provision is section
against the interim order, appeal against
section 9 na
section 17.
Section 17. Just
this must be against the interim order. The appeal which you are seeing. 2017 appeal.
No, more list seta bharla. Kintu ye morikiri dita anko appeal asi.
You see, the language is Orissa Special Court Act 2006. Any person aggrieved by any order.
Any order. Yes.
So it may be interim order, but if you say final order also 17 lies. Appeal lies.
Yes.
So question is that if you are sure, then we'll dispose of, but otherwise, because he is not there, if you say that final order has been passed,
Yes.
we are recording your submission. Are you sure? Or we can take up this matter day after tomorrow.
Day after tomorrow.
There is no problem.
Yes, yes, I will, because
Date of final order also.
yes, yes.
We are just.
I will come with the file where final order has been passed.
ସେତିକି ଦରକାର।
I will come with the file.
This writ petition has been filed by the petitioner Charu Chandra Parida, challenging the confiscation proceeding, White confiscation case number 2 of 2012, which was initiated against him. And subjudiced before the authorized officer cutter, which is stated to be subjudiced in the before the in the court of authorized officer cutter. Mr. Sriman Das, London senior standing counsel, Mr. Das.
Yes, yes, ma'am.
Senior standing counsel. Senior standing counsel appearing for the state State Vigilance Department submits that the matter may be taken up day after tomorrow, so that we will apprise this court about the status of confiscation case number 2 of 2012. So also the status of the petitioner. You are saying that he is dead now in the meantime.
Yes.
All right. List this matter on 12th of September 2020.
Yes. And my lordship, so far as sub-item is concerned.
5 of 2012.
Yes.
It is pending.
It is pending, and that is CRLA 679 of 2021. That matter is pending. And so far as I have already filed counter in the present case, your lordship will find in paragraph.
No, if the matter is challenged in a appeal, so why it has been again filed here? This is CRL.
Secondary file.
No, secondary appeal file which goes in.
679 of 2021. What a confiscation.
That has been disposed.
That has been disposed. That is interim order.
Interim order.
That has been disposed.
And
my lordship earlier
5 of 2012 এটা
What is the stage?
Confiscation proceeding is pending. In my lordship, in this case, I have already filed my counter affidavit. Paragraph 4 ta khali your lordship may kindly peruse paragraph 4. Earlier similar issue he had raised, and in CRL 1 criminal appeal and 2 writ petitions, and he has not disclosed in the certificate also. And those cases have already been disposed of. And earlier he had challenged the constitutional validity on the ground of 5-1 notification is not covering his case. That in Divyadarshi Biswal's case, that has been finalized.
We are asking you one thing. In the second item, that is WPCRL number 77 of 2013.
Yes, ma'am.
He is challenging the confiscation proceeding number 5 of 2012.
Yes, ma'am.
Before the authorized officer.
So
it's a 12 means in the meantime 13 years have passed.
Yes, ma'am.
We want to know about the status of the case,
yes,
and whether this proceeding in any other like appeal etc. is pending before this court or not. What is your instruction?
My instruction is confiscation proceeding is pending before this authorized officer.
Yes.
Other criminal appeal.
That instruction you get.
Clarity is
You also obtain instruction about this. Pendency of that. Second, due to a connected item, which is WPCRL 77 of 2013. This writ petition has been filed by petitioner Ghanshyam Mahapatra. This WPCRL challenging the confiscation proceeding by confiscation case number 5 of 2012. stated to be pending before the authorized officer cutter. Stop. The learned counsel for both the parties shall apprise this court about the status of confiscation case and also if any other matter arising out of the said confiscation proceeding is sub judice before this court or not. है ना? सीधा आगोटार भी लिखी देवे से या जोटा फर्स्ट आइटम डर है ना? Status of so and so plus any other thing here. And you give the other cases which you are filed so that we can dispose of it. By a competent officer,
Yes.
you file an affidavit that against challenging the confiscation proceeding, this proceeding was initiated and it was disposed of. Who order the copy upon the so that it can be disposed of on the.
Whatever you have disclosed in para 4, copy of those orders and all.
You have filed the counter affidavit.
पुराना order
You have to find it out. Everything is on
Call your officer, and it is matter is pending in Kata court. Also, that information you can take.
Yes, yes.
And now you see, an order has been passed that they will file an adjournment petition and it will be adjourned.
Yes.
So it is going on and on.
Yes,
Last order was passed in 2014, and we are taking up this matter now.
Yes.
So they are enjoying the confiscation proceeding. Perhaps seems to be is not over.
And so far as my lord, I may submit one thing. So far as the issue is concerned, my lord has already been decided in Sadanand Mishra's case, and
You just bring it, we'll dispose upon on that day.
yes, ma'am. I have.
Next.
My lord, so may I pray that if it will be uploaded today, it will
Which
be
one?
those orders.
These orders will be uploaded.
Okay.
And a free copy of the order be handed over to Mr. Das also. Yes.
Next week next week की रहिले के सब जान को क्लियर कर जाएं। से भी कहते हैं next week रे रहिले हमको के आनी आपने बेटर का सब next week
केबे कौन आती
any day मंगलवार
में बुधवार और दूसरा
बुधवार
अच्छा put up this matter on 24th of September 25.
Yes.
But take it for granted we will not adjourn
No,
this
no,
matter
yes.
on that day. Yes.
No adjournment is legal.
देखिए no further adjournment.
Item 2.
Yes. Convictions. 302. All right. Admit. Call for the trial court report. Interim application for Swan. This will be considered. Deposition copy to be supplied. This.
Item 3.
Applications are not there. There are two applications.
Two applications are there for bail and sterilization of file.
That will be considered after receipt of the trial.
Item 4.
It a delay. No, तीन number टा रखी ना
Item 3.
तीन delay condone कर देवे 27 दिन ना और admit कर देवे और council को से जो list है serially करी engage कर देवे है ना same it received in time other delay condone दर्शन तो नहीं इधर simply admit होगा बड़ा सब 302 केस था देख दीजिए जल्दी
Up till item 6.
इतने पूरा तादेर जो ये थी वजह दी जो 376 3 की अमोक समोस थोड़ा कोई देवे so that otherwise 302 is all right 154
That 2 is the foxage.
Putre
2.
item number 2 रे ना 2 टा का पूरा 302 रे ये जी conviction है कि
56.
Item number 2 is
Sorry, 3 minutes. 143 minutes.
142.
3. This year 142.
Just a minute, let us see that. 6 142 रे notice कर देवे तुमको है ना advocate engage कर देंगे से states तांकर से notice देवे तो informal है ना अब से जो हमारा जो order pass हुए जो legal services authority ना से करते तापरे इटा 4 टा होची 302 5 टा देखो चेक करो ना नॉट आइटम नंबर 5 रो जजमेंट टा देखिए 302 admit ଅଛି time ଅଛି ତ admit କରିବ 6 item ଅଛି now receiving time 3 તમે તો લિસ્ટ રખજો છો જો એડવર્ટમાં એન્ગેજ કરાવો હા યસ નેક્સ્ટ 6 টা 302 સબ 302 yes 7 item 7
Item 7.
appeal you learning it is 146 I mean it includes both single bench as well as division bench no division bench the list next
Item 7.
next
Item 8.
why they are not appearing and why they have been interested 7 to appear on finance why they will be
Item 7.
Rajiv can the advocate no nobody is present say you list or next na tatang de do the name of this council Ramesh Mati Swanso shall not be reflected in the cause list Hello? And
9/1/2020 order
paper book has been prepared that is to be no they are not responding why their names should be there if they are not doing any grace court has appointed them as amicus curiae and they are not appearing this is jail criminal appeal of the year 2011 so
They should give more priority to this kind of case.
yes yes Samarjit Panda is not there engage the next man and the paper book brother he अच्छा ठीक है ये ना एगुड़ा सब ना ये करे कि नहीं है ना लिस्ट करे दी नोड़ा सब शुक्रवार दिन आना कुछ पहले ना एंगेज करें ये जो मैटर उड़ा
My lord.
Okay. Next item number.
No, 1 minute. Samarjit Panda.
My lord, item number 8.
8.
Yes.
Pray for adjournment.
You are Mr. Samarjit Panda.
I am associates of Mr.
Why are you
Samar.
seeking adjournment? It's a 2015 jail criminal appeal.
Yes, my lord.
No, if you are not interested, there are we can engage some other counsel. It's not the private brief that you will take adjournment.
My lord senior is 8.
Yes.
Sorry.
Ask your senior that it will be taken up on Friday. Yes. Next. Not it is not a thou. Is your Samarjit Panda karo, but list this matter on Friday.
My lord.
12/9.
My lord, matter should come after vacation.
No. Disengage, Mr. Samarjit Panda. Engage somebody else, and matter will be listed on 12/9. Yes. Next.
Item 9.
Yes.
Matter number 9, ma'am. No. Your lordship has granted interim bail of 3 months, ma'am. 26
Because your criminal appeal ଅଛି ଯୋଉଥିରେ bail file ହେଇଛି those have to be listed prior ତାକୁ preference ଦବ to the criminal appeal ଆଉ କହିଦବ dealing assistant ଯଦି କୌଣସି matter jail criminal appeal ର ଯଦି pending ରହେ yes
item number 9, ma'am.
yeah
The lordship has disposed of the I 125 of 2024 mirrored by order dated 26/11/2024. Granting mirrored 3 months.
3 months, huh?
3 months.
Surrender.
He surrendered in time. He was at Ralph jail and he surrendered at body. That is that surrender certificate I could not get.
you want some more time to
No,
file
your lordship has in the last occasion, your lordship directed my lord to register to direct.
no there is no such order is there any order 26/11/2024 ର ଏଟ order ତାପରେ କିଛି order pass ହେଇଛି କି ଦେଖିଲ କେବେ order କରିଥିଲି
No, there is no other order.
there is no other order
It's a jail penal appeal, my lord, I could not obtain that.
no that's what you said that we have asked the registry to find out from the London trial court whether that man has surrendered or not.
He surrendered, my lord. I got the news that he surrendered.
That is to be confirmed because you are not filing the surrender certificate.
That certificate is not open.
So that is what.
Let the report be.
That is what you said that. Because the last order we find, order number 6 is that you are to file the surrender certificate. It's at a last order, no?
Order number 6 la.
The Mr. Biswajit Naik, Land Counsel for the appellant is present, submits that though he has received instruction that appellant has surrendered before the trial court, London trial court, after availing the interim bail period as per order dated 26/11/2024, but is unable to produce the surrender certificate since it's a jail criminal appeal. Stop. In view of such submission, let the file be placed before the London Register Judicial for sending email to the London Trial Court and obtain instruction as to whether the appellant has surrendered or not. Hello? Report be produced. Reports shall be sent through email such and such date and file matter be listed on 22nd September 2025.
Item 10.
I think we have allowed the Lakshmi also directed to take instruction regarding the conduct of the trial.
'When the interim bail order was passed?
Interim order was passed, 24/6/24 or 8/1/23?
No, last time.
8/1/25. 8/1/25.
8/1/25. Eight 125 पूर्व ଆଉ ଗୋଟେ ଯାଇଥିଲେ ତା କଣ
ଆଜ୍ଞା 24/6/24
24/6/24 ଯେତେବେଳେ ବି ଆସିଥିଲା ଆମେ we have reflected in the order dated 8/1/2025 that you produce the written instruction that during the interim bail period the conduct of the petitioner was good and nothing else. The written instruction received from IAC Town Police Station, Closure, dated 10/9/2025, which indicates that during the interim bail period, no adverse report has been received or found against the petitioner. The written instruction is taken on later on. It appears that in connection with this case, the petitioner was taken into judicial custody on 16/2/2016. And during the pendency of the appeal, the petitioner was granted interim bail twice. First time by order dated 24/6/2024 for a period of 3 months. 3 months. Again, I had order dated 8/1/2025 for a period of 3 months. Since the petitioner has not flouted the terms and condition of the interim bail order as per the report submitted by the Lion Council for the state, and there is no likelihood of the appeal being taken up for hearing in the near future, we are inclined to release the petitioner on bail allowed.
Placing reliance on late.
Late case.
Twice interim bail granted, placing reliance on late.
Yes, next.
Item 11.
May I please, Your Lordship? My Lord, in IN number 22/25, my Lordship, by virtue of order dated 22/25, the appellant was granted interim bail for period of 3 months. And right time I surrendered on 3/6/25 on order dated 17/6/25. That is my surrender certificate, my Lord. On 17/6/25, orally I take instruction that is also right then.
You are in custody since 7/9/2018.
My Lord, 7 years.
Three six 25.
3/6/25.
So you have filed another bail application.
No, my bail application is pending. Interim bail application was disposed of. My bail application, regular bail application is pending. That is IN number 270/24.
No, you are granted interim bail in
IN number 22/25.
by order dated?
Order dated 22/25. A period of 3 months.
Achha.
My Lord, another aspect I want to bring knowledge that I got one certificate from the jail superintendent and other officers. That certificate of training program, my Lord, kindly have taken into record.
What is that?
One of them.
Good conduct. It's a late.
So where are you giving it? Give it with Xerox copy.
Xerox copy.
This is regarding your conduct.
My Lord,
Jail conduct. But what about the outside conduct?
There is no adverse.
Whether you're doing very good in jail, remain.
But I also thought in 1 minute that
No, now whatever you have learned from the jail, that should be utilized properly while you are remaining outside. So
whatever I got instruction from that his mother and other persons that they told me they work when you in time of interim bail outside worked and gave money to her mother.
That's
three small
He
children.
worked as a daily laborer during his interim bail.
That is the reform. Your mother is 70 years old.
70 years. My Lord.
You have a daughter and son.
But she has been
11 years and 10 years.
The Land Council for the petitioner has produced the surrender certificate which is taken on record. This is surrender certificate. Land Council for the petitioner has produced a certificate issued by the Senior Superintendent Sub-Regional Barampur, which shows that he has successfully completed the skill upgradation training program on weaving with Adobe in Sub-Regional Barampur. The certificate is taken on record. The petitioner was directed to be released on interim bail as per order dated 22/2025 for a period of 3 months. And the Land Council for the state has produced the written instruction received from IIC Hinjali Police Station dated 26/2025, which shows that during the interim bail period, nothing adverse was found against him. Rather, he was doing labor work and spent those days with high integrity. And his conduct during the interim bail period was found satisfactory. We have taken note of in the submission of the Land Council for the petitioner in the order dated 20/2025 that the mother of the appellant was aged about 70 years and the son is aged about 11 years and 8 months and daughter is 10 years, 4 months. Now, we have taken note of the written instruction produced when we passed the first bail order on 22/2025. The written instruction received from the state, like mother is so and so. And she is taking care of the, mother is taking care of the son and daughter of the appellant. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, the conduct of the petitioner inside the jail, and also his conduct during the interim bail period, we are inclined to release the petitioner on bail. Obliged to allow. You follow the history of the which item you are?
Item 12, first.
CRLA 5 of
5 of
2012.
2012.
The offense is under section.
396, 302. There are 3 murders.
So your bail application was earlier rejected.
Yeah.
When?
It's in the year 2014.
First on 6/3/2012.
6/3/2012.
Yeah.
Then?
No, after this is second.
Just a minute. Yes, we passed the order that on 11/8/2025 that this criminal appeal was filed by 2 persons. But that man, Happy alias Birolal Sahoo,
He has
he
been released.
preferred a separate appeal,
Separate appeal.
jail criminal appeal.
48 of 2012.
48, and he has been directed to be released on bail.
Yeah.
So this appeal now is confined only for this Inda alias Interim. Okay. And your submission, we have recorded in the order dated 16/7/25 that he is in custody for more than 17 years. And we asked the learning state council for some instruction about the criminal antecedent. So state council produced the custody certificate, which shows that you are in custody for more than 19 years. So obviously it
Near
was,
17 years.
huh?
17 years, 6 months.
But including that remission, it goes to 19.
Including remission is 9.
And what about his criminal antecedent?
And there is no criminal entity.
Or the learning council for the petition or learning council for the filing.
Do you have any problem?
The connected appeal is a similarly situated person, Kabuli Aditama, the CRLA 3 of 2012. His bail application has been rejected and which has been confirmed by the Apex Court by 11/8/2025. That is a flag jail.
Rule attributed same.
Almost.
But what about Hira?
One has been gone on bail, another has been rejected.
There are 2 persons on bail. One is CRLA 4 of 2012 and the CRLA.
No, we are granting him at this stage, we are granting him 3 months.
3 months.
Let us see his conduct.
Conduct as well.
Because you have got that nothing adverse was.
Nothing adverse.
That one. The no, say first item. On 11/8/2025, when this bail application was taken off, this is IN number 1219 of 2025. An application for bail in item number 12, CRLN number 5 of 2012. When the matter was taken off, bail application was taken off on 11/8/2025. The Learning Council for the state produced the custody certificate of the petitioner, which shows that the petitioner is in judicial custody for more than 19 years, including the period of remission, right? The order passed on the very same day also indicates that one of the co-accused, namely Happy alias Birolal Sahoo, who though preferred this appeal, but again filed a separate appeal, that is jail criminal appeal number 48 of 2017, has been directed to be released on bail by this court at order dated 24/6/2024. Stop.
We asked the Land Council for the state to obtain instruction regarding criminal antecedent, if any, against the petitioner. And today the Land Council for the state has produced the written instruction dated 11/8/2025 from IIC Model Police Station, Khurda, to show that there was nothing adverse against the petitioner. The written instruction is taken on record. So, considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody and absence of any criminal antecedent against the petitioner, and release of the accused on bail, we are inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activities, and the inspector in charge of Khurda Police Station shall keep a close watch over the activities of the petitioner while on interim bail, and he shall also appear before the IIC Khurda Town Police Station once in a week on every Sunday in between 10 to 4. Violation of any terms and condition shall entail cancellation of bail. Put of this matter on such and such date, the Land Council for the appellant shall produce the surrender certificate and the stop. That's all. No. Next.
Item 13.
Please, your lordship, my lord, on 6th August, the receipt for
Lordship has called for custody certificate, conduct and seal. Data copy.
He was never released on bail. How many times your bail application was earlier rejected?
Yes, my lord. Sorry, my lord, once.
Once. On what date?
My lord, that is the application number 576 of 14.
27/2015.
Just a minute. 27,
2015. Yes.
Satisfactory. Period of election. What is the period under 4,461?
461.
Yes, sir.
4461 days, almost 12 years, 2 months.
Okay.
Not
बाकी ये रहा कौन? Nothing of it. Let's go. The
Yes.
Land Council for the state has produced the report received from Superintendent District Jail Jungjar dated 8/8/2025, which indicates that the conduct of the petitioner inside the jail was satisfactory. She has also produced the custody certificate to show that the petitioner is in judicial custody for more than 12 years. The certificate and the custody certificates are taken on record. The custody certificate and the conduct certificate taken on record.
the bail application, earlier bail application of the petitioner was rejected by this court by order dated 27/2015. Considering the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on interim bail for a period of 3 months. बाकी ताদের जो अरेस्ट करथिले सेडा सब करदेबे यार आईआईसी देखिदेबे ये जो थाना होची पाटना थाना दी डिस्ट्रिक्ट ऑफ केउंझर है ना सेठी हाजिरा मारियो सप्ताह थरे रविवार दिन ये क्लोज आवर्स रखिबे और नो क्रिमिनल इंडल्ज इन है ना बाकी गोटे स्टे एप्लीकेशन अछि स्टे रियलाइजेशन ऑफ फाइन सेटा को अलाउ कर देबे यस बाकी ताদের রয়্যালটি ওই সারেন্ডার সার্টিফিকেট দিয়ে সব আছে সেটা পে করি ও 3 months বেল দেন next
Item 14.
Item of 14, your worship has called for a custody certificate.
Yes.
We are unsure about in which jail he is in.
Huh?
The reports are that he was in Sambalpur jail for some time. Now he is not in that particular jail. So I request some more time to get the custody certificate.
He has shifted to some other jail.
Some other jail.
So you have received the instruction to which jail he has.
Not yet, your worship.
So
Request some more time. I will inquire and
because
get this
that is to be ascertained and
Yes,
again
report has to be called upon that.
the Learning Council for the state submits that though initially the appellant was in Sambalpur jail, but he has been shifted to another jail and therefore she is not able to produce the total custody period certificate and the matter may be taken up on some other day. 22 तारीख रखुछु?
Yes, sir.
22nd of September 2025. Yes. Good.
Item 15.
Item 15. May I please read it? After availing the fat time of interim bail, my lord, to surrender before expiry of the
When you were granted first bail?
first bail on 15/7/2023 for the period
केवे?
13/7/2023
अच्छा.
for the
कितने समय bail?
8 weeks.
8 weeks.
Let's say.
ठीक समय surrender करछंती? ଆଉ कौन रिपोर्ट आसिला से जो period रो?
Report is yet to be called for. Submitted.
Report.
No, that the state.
For the report on 21/5
And
5/8/2024 a report मंगाई थी.
just a minute.
I'll submit it.
No, another time as it appears on 28/2024, you are also granted bail for 3 months.
3 months.
So you have been granted bail, that means twice you have been granted bail.
3 times, my lord.
3 times.
My lord.
So date गुड़ा कौन केवे सर?
First was on
order रे आपण जाइछंती bail.
First was on 13/7/2023.
13/7/23.
My lord. For the period of 8 weeks. Then 15/3/2024.
15/7/20.
15/3.
15/3.
Order dated 15/3/2023.
हाँ सी order date गुड़ा कौन? 13/7/23, 15/3/24 तापरे?
तापरे 20/8/24.
The first time 8 weeks.
8 weeks. Second time also 8 weeks. Third time 3 months.
8.
Conduct आनी ना दिया वो. नहीं है.
Next.
ଆଉ ବାକି ତାର ପିରିୟଡ ଟୋଟାଲ ପିରିୟଡ ଟା କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ସେଟା ବି ନେଇ ଆସିବେ
ସେଟା ଅଛି କିନ୍ତୁ ବିଫୋର 1 ଇୟର ଲାଷ୍ଟ ଇୟର
ସେଟା ଏକ୍ସକ୍ଲୁଡ ହବ ନା ଏଇ ଯୋଉ ବର୍ତ୍ତମାନ ହେଇଛନ୍ତି ଦେଖନ୍ତୁ ଦି ଆଇଏନ ନମ୍ବର 920 of 2025 है ना there is an application for bail. The Learning Council for the petitioner submits that the petitioner has been granted interim bail thrice. That is by order dated 13/7/2023 for a period of 8 weeks. By order dated 15/3/2024 for a period of another 8 weeks. And last time, I had order dated 28/2024 for a period of 3 months. You have to check all these orders. And after availing the interim bail period, he surrendered at right time. Learned counsel for the state seeks some time to obtain instruction regarding the conduct of the petitioner while on interim bail. So also to produce the custody certificate. Put up this matter on 22 तारीख रखो जी मैडम.
Yes, sir.
22nd September 2025.
Date will-
Yes.
Item 60.
Take just get a call.
That custody, the interim bail period, the conduct I have received, sent it.
Anichandi?
That's all. Just now I have received that I have come. No adverse is there.
ଆପଣ interim bill କେତେଥର ଯାଇଛନ୍ତି? କେବେ? Order dated?
30/23.
How many years you were in custody? 12 years. Custody certificate produced for them? Produced.
Custody certificate was granted.
Oh, that was considered and bail was granted. अच्छा 30/23 order टा बाहर करो.
नहीं, thereafter consider custody certificate was called for.
No, that was not mentioned.
Custody certificate
produce कले custody certificate बोली custody certificate टा पड़ा.
12 वर्ष 2 मास 19 दिन.
हाँ इटा अच्छी तो.
Long period.
हाँ 12 वर्ष इटा होची केबे करो. এটা 2025 আছে
that was called for.
66/8/25. So it shows 12 years, more than 12 years. Diyon, sir. ये ଆଉ ଦିଟା କଣ କେସ୍ ଆପଣଙ୍କ ନାଁରେ ବାହାରିଲାଣି? ବିଜୟ କୁମାର ରାଉତ ଏଇ ତ?
ବିଜୟ ସଞ୍ଜୟ
ଓ ସଞ୍ଜୟ ନାଁରେ କିଛି ନାହିଁ. ସଞ୍ଜୟ ନାଁରେ ହଁ ଏଇଟା ଗୋଟେ 8 ଗଡ଼ PS କେସ୍, ଆଚ୍ଛା ଗୋଟେ ଅଛି. 341, 323, 244, 506 बाकी विजयनार अच्छी दीटा केस ना एक केस में डाल दीजिए मास्टर ट्रैवलर बाकी आपण तादरे भी बेल फाइल करछन जो विजय राउत रे से भी से पीरियड रही सेम पीरियड फास्ट लिखु CRLA नंबर 759 of 2018. This is an application for bail. The custody certificate, which is available on record and dated 6/8/2025, issued by the Superintendent District Jail Lengana, shows that the petitioner's custody is more than judicial custody period is more than 12 years. Stop. The petitioner was granted bail, interim bail, for a period of 8 weeks. 8 weeks by the order dated 31/2023. And the Land Council for the state has produced the written instruction dated 4th August 2025 from the IIC Atharwad Police Station to show that the during interim bail period, nothing adverse was found against him. However, it is mentioned that the petitioner has got one criminal antecedent.
Sanjay 1, Vijay 2.
हाँ, petitioner माने इटा में order टा डाकू संजय एक stop. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, and this, since the petitioner has not misutilized his liberty while on interim bail granted on the by the order dated so and so, we are inclined to release him on interim bail for a period of 3 months. है ना? अच्छा, सेकेंड रे आपण इंटरिम बेले जाइथिले
2-1-23 8 weeks.
The 8 weeks. तादरी सेमती लिखिबे द ऑर्डर डेटेड होची 2-1-23 से जो सेकेंड रे विजय कुमार राव देखिलो तो तादरे 8 weeks रे जाइथिला ऑर्डर डेटेड होची 2-1-23 कंडक्ट एथर अछि है ना यार दीटा कॉपी कर देबे से आदर गोटे तादर गोटे कारण दी जण पर आछि अब आनार दीटा क्रिमिनल एंटीसिडेंट अछि है ना तेसी सिनेमा दे दे है ना
Item 17.
Yes. Exactly. Petitioner was released on interim bail and surrendered in time. The surrender certificate was already filed.
The report is there.
Surrender certificate. ठीक है. You have filed a bail, another bail application. 559. मेरिट रे आपनकर बेल रिजेक्ट हिची आगुरो हां 140 केबे 7/8/2020 7/8/2020 rejected on merit. Thereafter he was released on interim bail on 4 occasions. 4 occasions my lord केबे केबे 22nd 9 2023 22nd
22
22/9/2023
मैम हाँ 22/9/2023 हाँ
आइए नंबर 405
जस्ट ए मिनट हाँ आदर केते समय गला 4 मास
4 months
4 months okay then
10/9/2024
10/9/24 केते मास
17 days
काहे कि एमती गले
फादर एक्सपायर कर जाए
watch
Father is co-accused.
17 days
Paramananda Bera.
apply number 2
then 14/5/25
for 3 months
14/5/25
3 months
3 months yeah
then 28/25
और ये 8/2025
बीमार 15 दिन पर 15 days रीजन व्यापार वर्षिका
so any adverse report against not that and what would be the period of custody
for 6 months 6 years to 1 month
आपको exclude कर देगी
exclude करी हाँ ये पीरियड भी exclude कर दी offense of the 304B and the reason was not assigned why life imprisonment was awarded. The policy of the sentencing was not reflected in the judgment because minimum sentence is 7 years. If the court wants to inflict higher punishment, that must be reason.
304B life imprisonment.
Yeah. Without assigning reason.
All right. Are the land council, Mr. Mahapatra, and senior advocate, land council for the state. Mr. Mahapatra submits that the bail application of the petitioner was rejected on merit on 7/8/2020. However, he was granted interim bail 4 times. That is by the order dated 22/2023 for a period of 4 months, by the order dated 10/9/2024 for a period of 17 days, by the order dated 14/5/25 for a period of 3 months, and by the order dated 28/2025 for a period of 15 days. He further submits that the petitioner was found guilty under section 304B of the Indian Penal Code. Apart from other offenses, and even though the punishment is prescribed, the minimum punishment prescribed of 304B is 7 years, but without assigning any specific reasons, the maximum punishment, that is imprisonment for life, has been awarded to the petitioner. He further submits that since there is no chance of early hearing of the appeal in the near future, and that nothing adverse was found against the petitioner who have misutilized his liberty during the period of interim bail, the bail application may be favorably considered. Stop. One counsel for the state has produced the written instruction received from ACP-IIC, Lalbagh Police Station, Cuttack, dated 10/9/2025, to show that during interim bail period, no allegation has been made against the petitioner. The instruction is taken on record. Considering the submission, he further submit that the petitioner is in judicial custody for more than 6 years. Considering the submission made by the land council for the respective charges, period of detention of the petitioner in judicial custody, fact that the petitioner has been released 4 times on interim bail, and there is no allegation of misutilization of liberty in any manner while on interim bail, and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Item 18.
Right, 18, my lord. I have filed a comprehensive affidavit. For that, they have provided incorrect information. I press on other time.
Incorrect information মানে
फैमिली हिस्ट्री पूरा दे दे तो बात है कि हम कोई कला जी तो कंफिकेशन जो एफिडेविट में आनी है तो ये प्रेस मारने
Acha. The Land and Council for the state submits that he has received the comprehensive affidavit relating to the status of criminal cases instituted against the appellant from the Land and Council for the appellant, and after and he has sent the same to obtain instruction to the concerned authority. But necessary instruction has not been received, and therefore some more time will be granted to obtain instruction on the comprehensive affidavit. Put up this matter, do we commencing from 22nd September 2025.
I have filed another affidavit, two affidavits regarding the co-appellants who has also 4 antecedents. He has been released on bail. Another affidavit has also filed there.
No, see, what about this man?
This man
If bail is IGV antecedent, that is not a ground to grant you bail yet. 22nd of
4 cases. Same of
2025, yes. Next.
Item 19.
Item 19, my lord. My power, look and so on, and art program may be deleted. Item 19, look and so on, art program power may be deleted.
Now it has been received regarding engagement of Mr. Mangu Nandi.
Yes, ma'am.
You are Mr. Mangu Nandi. You have filed your power. Mangu Nandi for a power dekhi. Right. Listen. Here is the prisoner's petition received from Faisal Jail Atgad, which is at Flag D, regarding engagement of Advocate Mr. Mangu Nandi. Mr. Nandi has filed his wakalatnama, which is accepted. The name of Mr. Julu Khansama and his associates shall not be reflected in the cause list henceforth. Hello? अच्छा दीपक कुमार पंडा का ना रहिबो मंगू नंदी कर ना रहिबो आर प्रधान को नाटा बोले कटि जीवो अच्छा द नेम ऑफ लिखि दियंतु एसोसिएट्स जगह एसोसिएट कर देबे द नेम ऑफ मिस्टर स्वानसो एंड हिज एसोसिएट आर प्रधान कर देन shall not be reflected in the cause list. Yes. Now you have filed an application for bail.
No.
So how many years you are in custody?
I copy maybe
Around 10 years. You have not given a copy? No. So give him a copy. IN number 23 of 2021. This is an application for stay of realization of fine that is allowed. IN number 24 of 2021. This is an application for bail. Let a copy of the interim application be sought on the Land and Council for the state during course of the day. The submission of the Land and Council for the petitioner, it is that the petitioner is in judicial custody for more than 10 years.
Nearly 10 years now.
About 10 years. Let the Land and Council for the state obtain the custody certificate, conduct certificate from the jail, as well as take instruction regarding the criminal antecedent, if any, against the petitioner. Put up this matter on 22 9 2025.
God bless you.
Item 20.
20, Mr. Mishra? Yes.
Petitioner is custody for more than 14 years and
State to produce custody certificate, instruction about so and so. Anchandi?
information cover this.
Put Anchandi.
adverse
बेल रे जाइतला जो इंटरिम बेल रे नथिंग एडवर्स वाज फाउंड केबे जाइतले की बेल रे
इंटरिम बेल जाई
इंटरिम जाइने सेटा भूल देছে जब मगाइतला क्रिमिनल एंटीसेंट अदर थिंग्स सेटा नथिंग
एनीटा जिंस मगाई दिला
जेल कंडक्ट
कस्टडी सर्टिफिकेट जेल कंडक्ट और क्रिमिनल एंटीसेंट
सेकंड सेटा न दे एटा नथिंग फाउंड एडवर्स विल दे दिस राइट
नथिंग एडवर्स केमसे जाइनी और बाहर केम दिया आसिला बेल जाइछि क्या गुजो मना
नहीं
बेल
नहीं
जाइन और नथिंग एडवर्स
मे बी जेल कंडक्ट
जेल कंडक्ट
जेल रे किछि नथिंग एडवर्स
ठीक अछि आपण आनंतु से अच्छा देखि कोन नाही से रिपोर्ट कोन जेल नो
नहीं नहीं आईआईसी दे
आईआईसी केमति जेल कंडक्ट दो एटा कोन लिखछि मैं आईआईसी देइछि वेरीफाइड द सीए ऑफ ना कोन की श्रीबोस बेहरा हां एटा होछि तार ना क्रिमिनल एंटीसेडेंट किछि नै ऑलराइट सेटा को टेकन ऑन रिकॉर्ड कर दियौ एटा लिखि दियंतु आईए नंबर अच्छा आइटम नंबर 20 आगे लिख दियंतु आईए नंबर 859 of 21 this is an application for stay of realization of fine that is allowed बाकी आईए नंबर 1668 of 25 this is an application for bail the land council for the state has produced written instruction dated 10/9/25 from IIC Kishornagar police station to show that there is no other criminal antecedent against the petitioner. The report is taken on record, है ना? बाकी रहेला, he submits that some more time may be granted to obtain the custody certificate and also the instruction regarding the conduct of the petitioner while in jail. Put up this matter on 22 तारीख से 22 no yes.
Item 21.
May it be Lord. Finally, IA for interim bail or exception on the ground of appellant has been suffering from serious skin diseases.
Appellant
Nijoro. And everywhere there are wounds in the body or lordships. That has not been taken care of. It's the first time I see.
Oh, देना दी कॉपी देना
Copy दिया ही
आउट दे दियो नहीं जेरोस करी दे दियो दी लिखो आईए नंबर item number 21 IN number 2458 of 25 this is an application for interim bail and the ground has been taken that the petitioner is suffering from skin diseases and several wounds are there on different parts of his body. The Land Council for the laid a copy of the interim application be served on the Land Council. Served. Copy of the interim application has been served on the Land Council for the state who seek some time to obtain instruction and specifically whether the petitioner is suffering from any skin disease and whether he has been given any medical treatment in that respect or not. Put up this matter on 21 तारीख ये sorry 22 तारीख सर 22/9/2025 में.
Item 22.
Mr. Panda, it is your matter.
Mine. Here I have prayed for bail.
Here.
I am in custody since 17th of November 2018, millions. And have been convicted on section 302, 301, read with 34 IPC.
Bail rejected earlier?
No. Earlier, your lordship, while not being inclined to grant regular bail, granted me 8 weeks interim bail.
By order dated?
That is by order dated 23/9/2024.
23/9/24.
And that has been extended subsequently.
अच्छा 23/9/24 ଆପଣଙ୍କୁ ଦିଆ ହେଇଥିଲା
8 ସପ୍ତାହ
8 weeks ତାପରେ ଏକ୍ସଟେନସନ କେବେ ହେଲା
ତାପରେ ଏକ୍ସଟେନସନ ହେଲା 19/11/24
19/11/24 ସେଟା କେତେ ସମୟ
ସରି 17/1/25
ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ ଅପ ହେଲା
17/1/25 रे एक्सटेंड
ନାଇଁ 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 19/11/2024
ଆଜ୍ଞା।
19/11/2024 ରେ ଆଉ 8 ୱିକ୍ ଏକ୍ସଟେନସନ ହେଲା। Okay, then
my lords
17/1/25 रे
17/1/25 your lordship granted further extension.
अच्छा पुणी आउ 8 सप्ताह।
Yes. That is because of the fact that he had a spinal problem. The bail had to be
2025 that was extended another 8 weeks.
Then I have surrendered.
Okay. The surrender certificate is on record.
Flag F, my lords.
Flag F.
That is annexure to my IFOP.
Annexure to the IA.
21/3/25.
Okay. Now, what about the conduct of the petition?
No adverse.
That report does not.
Get that report. Lekhandu. This is IN number 904 of 2025. Dr. Hrishikesh Tripathi means?
He's a doctor. He was posted at Chhatrapur during the incident. The government service.
302 case.
What is the story?
The role is like this, my lords. The deceased my lords had some affair with a lady who was a nurse in my clinic at Bahrampur.
Okay.
And he went missing on 19/8/2018. Then, my lords, the wife, that is PW14, lodged an FIR on 4/9/2018. And then the co-accused Ganga Behera was arrested on 12/9/2018. He made a confession that he has disposed of the dead body along with another co-accused and myself, my lords. Then I was taken into custody on 17th, my lords. And I made a confession and led to recovery of the surgical instruments with which the body had been dismembered. The allegation is that I administered a fortuitous injection which led to his death, and thereafter the body was dismembered and was buried in a pit meant for disposal of surgical waste.
ମାନେ ଆପଣଙ୍କ କ୍ଲିନିକ୍ସ ରେ ଏଇ ଜିନିଷ ହେଲା ବୋଲି
ଏଇଟା ହେଉଛି ପ୍ରୋସିକ୍ୟୁସନ.
No, you are also in relationship with that
lady.
I had no relationship.
But that's the allegation.
They say now.
Okay. कौन देखिए?
You are the hero, you are the villain.
See,
Together.
the IN number so and so, this is an application for bail. The Mr. Devasis Pandal and Council appearing for the petitioner submits that the petitioner was granted bail for a period of 8 weeks by the order dated 23/9/2024, which was extended for another period of 8 weeks by the order dated 19/11/2024, and for another period of 8 weeks by the order dated 17/1/2025. And after availing the interim bail period for 24 weeks, the petitioner surrendered before the London Royal Court on 21/3/2025, and the copy of the surrender certificate has been annexed to the interim application. Stop. Let the London Council for the state obtain instruction regarding the conduct of the petitioner while on interim bail. Put of this matter on 22nd September 2025.
May I pray one more thing? Along with conduct, custody period and antecedents of
the conduct inside jail as well as the custody certificate. Tinta vinayation. YC no 2025. So conduct. Yes, next.
Item 23.
May I please? 20. And today I'm placing the bail for criminal appeal number 419 of 24. In this case, 3 accused are there. Already 1 accused has been released on bail.
But 419 of 2024 appeal memo ଦେଖଉଛି କେବଳ ଅଜିତ ମହାନ୍ତି ହଉଛନ୍ତି appellant.
Yes, the 3 in the judgment 3 accused, 3 other bail appeal 3
କହିଲେ କେବଳ 419 ଟାକୁ ମୁଭ୍ କରିବେ ଆଜି ତ 419 ରେ ଜଣେ appellant ନା ତ you focus on that. ହଁ IN number କହୁଛନ୍ତି 803 of 2024. So whether your bail application was earlier rejected. Acha. How many years you are in custody?
And in the trial period, I am on bail. And now I am in custody from 6/3/2024 on the date of judgment.
Have you given the deposition copies to the State Council? Is it available with you, Mr. Nayak?
Deposition copy.
So give him the deposition copies. Left on. Item number 23. IN number 803 of 2024. This is an application for bail. The Land Council for the petitioner shall supply the deposition copies of all the witnesses examined.
Call for the CA.
To the Land Council for the state. Stop. The Land Council for the state has produced the written instruction received from written instruction received from IIC Patapur Police Station. Abronar out a case of
case
bail, my lord. My sister has committed suicide, and on that I am on bail.
No, se case ta bhi 302 ro na. Upon a case ro number kete
195. Yes, case number 195.
Eta hochi 195. So eta hochi first case. Ta mane second case ta hochi
192 302.
Eta hochi 2021 ro. Acha, while you were on bail, in the first case, you committed murder of your wife.
That's the allegation.
That is the allegation. 498 302 case.
Bail.
So what happened that case?
Bail.
No, about trial.
The trial is
Trial
is
going on. File a affidavit to that effect.
Yes.
The Land Council for the state has produced the written instructions received from IIC Patapur Police Station dated 28/3/2025, which shows that apart from the present case, another case was instituted on 26/12/2011 in Patapur Police Station by PS case number 434 of 2021 under section 498 302 A34 IPC and section 4 DPR. The Land Council for the petitioner submits that in the second case also the petitioner is on bail and the trial is under progress. Let him file an affidavit. Let an affidavit be filed in that respect. Put up this matter on the week commencing from 21/9/2025. It will be taken on the
deposition copy also.
Deposition copy called for the week with the deposition copy. She will supply during course of this week.
Item 24.
Mr. Mahanti, please.
Custody from 9 years to 7 months.
Chief custody certificate. And you have this is the first time bail.
Yes.
Have you given the interim application?
Yes.
Copy paijandi.
Deposition copy this.
No, interim application copy is it?
Copy is
Interim application copy nahi.
No.
Khali deposition darchandi. Supply the interim application. And he says that he is in custody for more than 9 years.
Appeal sign file.
Nahi to ki dekhi kouchandi ame kon eti jai dekhibu na kon check to ଆଉ ଗୋଟେ ଲିଖୁନ ଆମେ ଜେରକ୍ସ କରିକି ଏତେ କଥା କଣ ଲେଖୁନ ଇଏ ନମ୍ବର wants to this is an application for bail. The Lieutenant Counsel for the petitioner submits that the appellant is in judicial custody for more than 9 years. No. 9 years question though? Yes, 9 years. Lieutenant Counsel for the state shall produce the custody certificate. Let a copy of the interim application be served on the land council for the state. After बाकी जो अच्छी स्टे रियलाइजेशन ऑफ फाइन सेटा अलाउ कर दें and matter to be listed on 22 तारीख stay fine their matter to be listed on 22/9/2025 yes
Item 25.
Mr. Tripathi first time bail আসছে না আগু রিজেক্ট হয়েছে
No,
রিজেক্ট হয়নি ডিপোজিশন কপি দিয়ে দিয়েছেন ଅଛି কেস কোন
Case 76 madam.
76
Your lordship, before going to that case, madam, annexure 4, page 128.
376 and 376 बराबर 3 भी अच्छी नोटिस देख ना
सब
notice complete
senior
oh you are appealing have you received the copy of the appeal memo
yes
Vidhan Pradhan is online perhaps. So Vidhan Pradhan has given consent to appear on behalf of the victim.
no you are to appear
I am there. He is also given consent to appear.
who is Pradhan
Vidhan Pradhan, you are they are saying that he is lying.
Anyway, he has briefed you, no?
It's all right. So you have received the copy of the appeal memo
Yes.
right so yes it's a case of
376 madam. Two cases madam. Your lordship can have glance to page 128 madam. Annexure 4 madam.
FIR.
Initially my lord affair was lodged by another person my lord where the present victim's father was the scribe of the affair. Offense under section 354, 354D, 292, 67, 66 of the agreement. It was lodged on 23/7/2022 by the scribe of a victim of father. This case is
ଆମର ଏ କେସ ରେ victim ହେଉଛି ଗୋଟେ minor ଝିଅ she was reading in Swan's
last
school. So what is the present status
plus 3 portion
Mr.
Yes ma'am.
Mishra
He is reading in class plus 3 first year
plus 3
or second year first year.
second year.
okay
Case
कौन
initially that affair was lost by one of the victim man. Two subsequently after 7 days my lord this present affair against the present petition.
you are a teacher
Yes ma'am.
Teacher you are teaching to this victim this type of teaching
That there is no my lord if you have a plan case my lord in 2 cases Simon says
nude photographs were seen nude photographs
not seized my lord not produced before the court. Your lordship kind of the deposition my lord the photographs never produced before the court and it is the case of the prosecution. If your lordship go through the evidence my lord page 59 paragraph 3
victim evidence कर लो कितना PW कितना है
PW 1 minute page 58 I have annexed that to
Relevant portion quoted in para 10 of the judge.
Evidence.
3 minute
letting place accused was the teacher in our school teaching math and science ये कर दीजिए हाँ Master Penal also is directed to call for the immediate antecedent of
Criminal act, that report has come. What?
Approve bail reject any to? No, no. What is the offense here? Offense lot 30. Here lot occurrence. How many years you are in custody?
On the date of arrest, that is on 26/9/2021.
26/9/21.
My lord.
Eyewitness there?
Yes,
Lord. Eyewitness.
Who are the eyewitness?
My lord, here focus.
129.
एक में 2 9.
My lord.
Our PM doctor?
PM doctor PW 16.
16.
My lord.
Here, my lord, Uthre Marla. 26/9/2021 is the occurrence date. This is died on 14/10, my lord, after 15 days, my lord.
Yes. Treating doctor PW 10.
PW 10.
My lord.
Uthre Marla.
State.
State rate.
My lord.
Who person?
Head.
Two.
Head.
Ketda blow? How many blows have been given?
Blow.
Lacerated wound on this one, so lower mandible, page 14. How would the duita? Fracture ଅଛି right forearm. Okay. Why you assaulted him?
My lord, that reason, none of the witnesses, my lord, have said there was any
witness.
No. Regarding enmity between them, my lord, and motive was not brought.
An eyewitness motive.
Eyewitness person, yes, but there was no any
Only 3 years. One has stated that the accused were assaulted bikini. Bikini of Pudan is here?
No, lady.
Lady.
Yes.
With a spade. Mongolu, brother of the grandfather, intervened and accused took note of swans who fled away.
During trial, he was not bail.
ସେ କହୁଛନ୍ତି ପୁରା 21 ମସିହାରୁ ଅଛନ୍ତି ମାନେ
4 ବର୍ଷ।
4 ବର୍ଷ ବି ହେଇନି।
4 ବର୍ଷ, exactly 4 ବର୍ଷ, 26/9/2000।
ହଁ, ଏଟା ଛୁଟି ପର୍ବର exam. ଏଟା ଲେଖିନିଅନ୍ତୁ, the Learning Council for the state has produced the written instruction received from IIC Khunta police station dated 20/8/2025. Regarding Purna which is taken on that document. Put of this matter after ensuing puja holiday. Yes.
Item 27.
Mr. Das.
7/4/25 reject ହେଇଥିଲା ପିଲା। 7/4/25 reject ହେଲା।
7/4/25 ନାହାନ୍ତି ଆଉ। ଏଇଟା ଡିଟେଲ ଅର୍ଡର ପାସ୍ ହେଇଛି, ଏତେ ବଡ ଅର୍ଡର ଟା।
4% update.
Non appears କରି urgent कर दियंतु after puja holidays.
Item 28.
Mr. Saul.
Lady is in custody, my lord.
Reject ହେଇଛି।
No, fresh.
Deposition copy ଦେଇଛନ୍ତି?
Yes.
Offense କଣ?
302, my lord. Only last scene. PW last scene, my lord. October is PW 15.
Last scene keep
Mother and PW 10. Marriage 11 years back.
Last scene PW 10.
Yes, my lord.
You killed your wife or?
Yes.
Yes, sir.
ଘରେ ଛୁଆଙ୍କୁ ଛାଡିକି
PW 10 କିଏ?
PW brother. Brother of the deceased.
Brother of the deceased.
Yes, sir. Ramaraki lost this affair, man.
dead body was found from
in another
Kajuna.
village, another
No, take it on.
place.
10 number সাকি পড়ে আসুন। Last scene যে বলছি।
I do not
Paragraph
know
2 what?
the incident took place on 7/2/21. The accused Shankar had taken the deceased from our house and did not return. While we were at work, we came to know from our neighbor that the accused had left, saying that he would bring money from someone, and he had left the children of the deceased at our house. As it was late night, we told him to keep the children till morning. On the next day morning, I came to know from mobile phone that a dead body was lying in Ordinopoli
କେତେଟା ପିଲା ମନେ କର?
chapter. I suspect that
They were working as labor.
Yes, sir.
No, no. The
Accused.
accused was not
Labor.
labor. PW10 and his mother, they were working as labor.
He also labor. PW8 is the mother, man.
So where the dead body was found?
From a kaju field, man.
Okay.
Grammar ki lost this
ଆପଣଙ୍କୁ ଏଇ ଯୋଉ ପଚରା ହେଇଥିବ circumstance ବିଷୟରେ ଆପଣଙ୍କର କଣ ହେଲା ଯେ ଆପଣଙ୍କ ସ୍ତ୍ରୀ ସାଙ୍ଗରେ ଯାଇଥିଲା ସାକ୍ଷୀ ମାନେ କହୁଛନ୍ତି
ନାଇଁ ଅନ୍ୟ ସାକ୍ଷୀ ଆଜ୍ଞା ସମସ୍ତେ ହଷ୍ଟେଲ ହେଇଗଲେ ମଦର ଖାଲି PW8 your lordship kindly see.
No, you just read the evidence of PW10.
Yes, sir.
PW10 ଟା ହଉଛି ତ last in ର PW10 ଉପରେ ଆପଣଙ୍କୁ accused statement ରେ ପ୍ରଶ୍ନ ପଚରା ହେଇଛି, that is question number 21, 22, 23, these are all related to ଆପଣ କହିଲେ the transfer from your evidence as what? ସେ ହଉଛି brother in law. ଆଚ୍ଛା ତାପରେ ହଉଛି ମିଛ କଥା କିନ୍ତୁ ମୋ ସ୍ତ୍ରୀ ବାମ ହାତରେ SL
ଲେଖା ହେଇଥିଲା।
SL ଲେଖା SL କଣ? SL
କାଟୁ
ଓକେ। କଣ ହେଲା ଆପଣଙ୍କର ଡାକ୍ତର ବାବୁ କଣ କହିଲେ କେତେ ନମ୍ବର ସାକ୍ଷୀ ଡାକ୍ତର?
ଡାକ୍ତର 15
PW15.
Well, 80, there are 8 injuries.
ଛୁଆଗୁଡା କଣ କରୁଛନ୍ତି ଏଇଟା?
With the uncle's house. PW10.
What is the motive behind the commission?
Extramarital relation. Perhaps extramarital relation because the accused was apprehended from the house of
They are married and having 4 children.
Yes, my lord. The accused was arrested from the house of co-accused who is a lady.
Achha.
He has taken some money.
Like the weapon of offense, anything recovered at his instance?
No.
Any bloodstain?
Recovery, what are the witness turned hostile, leading to discovery? PW11 turned hostile. All the witness.
Any of the witnesses have said that he was in relationship with that.
No, all witness turned hostile.
Nobody has said.
So if motive fails, then
only last.
You see this PW10 who has stated about last scene, this date is 7/2/2021, and the dead body was recovered on what date?
That was recovered on
10/2/2021.
Yes.
So 3 days gap is there, and that too in a different place.
Yes.
How can you correlate it?
Only the accused taken the deceased from the house of PW10. And the petitioner is the husband of the deceased.
So
he has to explain.
No, he has not explained, but
and petitioner has also not lost any affair anywhere that his wife missing or
about the, let us say, suppose this would be the evidence. Is the evidence now, let us say it will finally adjudicate this matter. So can we convict this man when he was seen
he was seen in the company of his wife on 7/2/21, and the dead body was found 3 days after at another place. There is no other evidence.
My lord.
You are not proving any motive. You are not having any light leading to discovery,
Yes. All the
extrajudicial
witness,
confession, nothing is that.
all the witness turned hostile, my lord.
And
But the
this
accused is
man
the-
is not that he is married and having 4 children. So the result ultimately maybe possibility of this would be the result. Then he has already remained in custody, as you said, for a period of
More than 4 years. 4 years, 7 months. 18 to 21.
4 years, 2 months. Are the learned counsel for the petitioner and counsel for the state. Mr. Sahoo, learned counsel for the petitioner, submits that the case is based on circumstantial evidence, and the only circumstance available on record is the last scene of the petitioner in the company of the deceased, who is none else than his wife. And the petition, according to PW10, the last scene was on 7/2/2021, but the dead body was found at a different place on 10/2/2021, which is 3 days after. And therefore, it is very difficult to correlate between these two, and it cannot be said that there is no chance of any third person coming in contact with the deceased to commit the offense in question. Stop. The land council further submit that there is no chance of early hearing of the case, and there are good chances of success in the appeal, and balance of convenience is in favor. And he is having 4 children who are now staying in the house of in the house of Peter Dutton. No motive. And the prosecution has failed to establish any motive behind the commission of crime, and therefore the good chances of land counsel for the state also fairly submits that the only material available against the petitioner is the last scene evidence, and the doctor PW15 was conducted post-mortem examination, and opined that the cause of death was homicidal in nature. Considering the submission made by the land counsel for the respective parties, absence of any direct, he is in custody for more than 4 years regular, absence of any direct evidence, nature of circumstantial evidence available on record, period of detention in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail. Yes, allowed. Okay.
Item 29.
May I please, Your Lordship? I'm appearing to virtual mode, Your Lordship. In the present case, there are altogether 12 accused persons, Lordship, and the present appellant have been behind bars since 6 years, more than 6 years, Your Lordship. Have been convicted.
Yes. What about the criminal antecedent and period of detention, custody certificate? Have you received that? Stating that is more than 6 years in custody.
Your Lordship, we
No. That now is 6 years, 5 months. Okay. That is
The petitioner has collected the custody certificate.
but the you have this jail superintendent.
Yes.
You can take instruction. There is no.
No, I'm not disputing that.
You can take in
Because
it is
from the-
in the official pad. This letter.
Yes, I'm not disputing.
So number 2 about the CA we want just instruction.
Jail conduct and
Jail conduct and criminal antecedent.
No, never Mokai. Only direction was issued to.
All right, get it. IN number 2818 of 2024. Madam, what is your name?
Adyashakti Priya, sir, Your Lordship.
Adyashakti Priya, land counsel appearing through virtual mode, submits that the petitioner is in judicial custody for more than 6 years. To that effect, the custody certificate issued by Superintendent Model Convict Prison, Atgard, is produced with a memo which is taken on record. The Land Council for the state, however, seek some time to obtain instruction regarding the criminal antecedent, if any, within the petitioner, so also the conduct of the petitioner inside jail. Put up this matter on 22 September 2025.
Obliged.
Item 30.
Yes, sir.
May I please? But here the appellant is in custody.
You are granted interim bail,
My lord,
when?
my orders is P1 2025,
I have to obtain the conduct.
P1,
2025, my lord, for 2 months, my lord.
just a minute, let us see. No, perhaps the date is wrong. You are granted interim bail
On
on 24/12/20.
Sorry, my lord. And it was released on 4/1/2025.
That's a different
Yes,
matter.
my lord.
And what is his conduct in that period?
But I will obtain the conduct. My petitioner directed to serve a copy of deposition.
You have not given, let's give some. IN number so and so, this is an application for bail. It appears that the petitioner was granted interim bail for a period of 2 months. I had order dated 24/12/2024. Land Council for the state seeks some time to obtain instruction regarding his conduct while on interim bail. To also instruction relating to the criminal antecedent, if any, and to produce the custody certificate and his jail conduct. Stop. Let the Land Council for the appellant supply the deposition copies of the witnesses to the Land Council for the state in the meantime. Yes. This would be listed on 22/9/2025 साला बाकी मैटर गुड़ा का अच्छी शुक्रवार दिन